Good morning, everybody. Happy Super Friday. Welcome to TCF Live. It is a quiet start out there this morning in Courtlandia, but Judge Middleton is up and running. It's Landlord-tenant, which isn't always what we like here, but let's see what's going on. Sometimes we get gems out of these things.
Miss Miriam, could you join us, please?
She might not know that she's muted.
Yes. Miss Miriam, can you hear me? I seem to have the unmute function, but it doesn't really work.
Mm.
On the Aaron, who else do I have, Lydia?
Yeah, Erin Collins.
And she's paid up, Your Honor.
All right, well, that's the pattern for this morning. I had 15 cases and about 13 of them look like they've been resolved. So it's going to be an odd morning.
It's going to be a nice
Miss Miriam, could you join us, please?
Yeah, she's
Nice glasses, Lydia.
Thanks.
Miss Miriam, if you can hear me, it'd be helpful if you would respond. There you go. Can you hear me now?
Yes, I can hear you.
All right. Can you turn your camera on?
It is on.
Well, not at our end, but we'll do the best we can. Good morning. This is Judge Middleton. I'm at the courthouse in Centerville. Your landlords, Terry and Larry Richmond, are here, and their manager, Lydia Larrick. This is a property that you've lived in for some time over on 4th Street. We were just talking about the tornadoes, and I don't think they hit 4th Street.
No.
But your landlord wants you to move. She has filed a notice to terminate your tenancy. Filed it in January. You have a month-to-month tenancy. They're asking that you move, and it's called a termination of tenancy case. In that type of case, you have a right to hire a lawyer. If you cannot afford an attorney, you may request that legal aid may represent you or seek other legal advice. You have a right to have the case heard here in St. Joseph County, where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of today's day using the jury demand form. And you have to pay a $50 fee unless the judge waives the fee for your inability to pay it. You may be able to reach an agreement with the landlord by going through mediation. So far, that's never happened, but if both parties are interested, the court could make a referral. And you may be able to reach an agreement where you would agree to move by a certain date or time, and they would file what is called a conditional order of dismissal. In this case, they filed a termination of tenancy, and they wish you to move. Ms. Merriman, what's your position?
I'm in the process of getting a new place, but I won't be able to get in till end of April.
Where is that?
On it's 118 Miller Court.
Now, you've got Mr. Richmond here and Lydia, and you mentioned this is is this a hoarding situation?
It's a lack of cleaning situation. I wouldn't say it's necessarily hoarding, but
they want to condemn the house.
so I don't know that we have until the end of April with the city and Safe Built for her to get out. We've already
Postponed it. And the girl from Safe Built walked in and wouldn't even walk through the house. We have to have it inspected every 2 years. So we're forced to do this.
Well, That's something that I know about your properties. Almost all of your properties are in the city limits. And as opposed to some of our landlords, yours are all inspected and they all meet code requirements,
Correct.
which is a credit to you. But at this point, Miss Miriam, the city says the house is unsafe and the landlord is being pressured by the city to do something. So they're asking you to move, and they aren't going to wait till the end of April to do it, probably. The law requires that I adjourn this matter 7 days. 7 days from today is next Friday. And that would be March 20th. And then you would get 10 days from that day to vacate or be subject to being evicted. Ms. Richmond, you're here on that morning at 11.
Okay.
I'm gonna set you for 10:50 for this one.
Okay.
Miss Miriam, the law
Yes.
says you would have 10 days from that day to vacate or you'd be subject to being evicted, which essentially would give you till the end of March. It would give you to March 30th, and that's a Monday. March 31st, that's the last day of the month. That's on a Tuesday. So that's what they're asking for. Now, you can seek legal advice, but the house has been condemned, and they're going to have to get in there and make repairs and clean up to bring it up to code. So I don't know what your alternate housing program is, but I would suggest that you see if you can get in there sooner rather than later. But for the time being, I'm going to adjourn this matter for 1 week to 10:50 on March 20th. Now, I would like it if I could see you. I can't see you. I could hear you, and I believe it is you. How long have you
Yes,
been in
me.
this property?
Oh, I don't know.
I don't have her card right
She's
now.
since 2012.
Well, it's too bad it's come to this, but that's where we are. So I will see you next Friday morning by Zoom, once again, at 10:50 a.m. If the plaintiff gets what they ask for, you would have 10 additional days, which would be March 30th, to move, or the sheriff could come put your stuff out in the street. That's a very unpleasant process. You could also agree to some sort of move-out date, but as I indicated, the plaintiffs are under pressure from the city to get tenants out of this property. So they've got some concerns as well. Do you have any questions?
This next meeting is the same ID number?
Yes, it is.
Okay. Like I
All
said, I've got a new place, but I can't get in until till the end of April.
Well, you need to figure something out because they probably are not going to agree to let you stay that long. I don't know how you allowed this property to get into this condition, but that's not an issue. They're
I'm
simply
disabled,
asking.
so
All right. Does anybody else live there?
no.
All right, I will see you next Friday at 10:50.
At 10 what?
10:50, 10:50. We've got some wrinkles coming up in April. We lose 5 landlord-tenant days.
Oh, dear.
April 3rd is Good Friday. I wish we had that day, but I don't. So we've lost that day. Then I'm going to be in your neighborhood in April, and we're going to lose the 10th, the 17th, the 13th, and the 20th, which is a lot, but we'll see. Hopefully we'll work around that.
If you get down Get down there. You need to go to the stinking crawfish. Have you been there?
I won't be as far down as you. I'll be
Oh,
where I usually go. I come down there in February. In April, I get about halfway down.
oh, okay.
Well, let's talk about Aaron Collins.
She paid up, right, Lydia?
Yes, she's all paid up.
Through March.
Yeah.
So you moved to dismiss that?
Yes. I think she changed jobs, didn't she, Lydia, or
She
something?
did, yep. So
She got behind.
Well, those are the best kind.
Yeah. The easiest for sure. But we tried to help Marcia. I called DHS to see if somebody could come in and help her, and
they wouldn't help.
Well, that's your style. Is to try
I've
to.
gone in and cleaned her house before.
All right, I find I just show defendant has paid.
Okay.
Plaintiff dismiss.
Jeez. The garbage man is here. He's banging them.
Well, hey,
No,
I used to be a garbage man. I was the guy that rode around on the back of the truck.
oh dear.
And some people, little old ladies, when the garbage man came, it was like, that was the highlight of the week. I did that for 2 summers.
These
and
guys,
ladies would run out, bring us stuff, and
I think these guys
Anyway.
are Cuban. They're really nice.
all right. Well, it looks awfully dark there, so I'm not sure, but
It's
we're
raining.
good to go here.
We got rain today, but we needed it bad.
All right. Well, that takes care of your 2 cases, and
Okay.
one of them was dismissed, and then we're on just a spate of.
All right, ladies and gentlemen, once again, good morning. Welcome to TCF Live. We got a food review and a weather report in there from from Judge Middleton's Zoom court. All right, let's change it up. We'll stay in Michigan, but let's go to 14B in Washtenaw. This is Judge Washington.
All right, the quote call case of the state of Michigan versus Alan Gray, case number 25S00454.
Morning, Your Honor. After Lonnie Belkis for the people of the state of Michigan. Cameron Youngish on behalf of Mr. Gray. Mr. Gray, can you please follow me here? When you get up here, can you please say your name for the record?
Yes, Alan Thomas Gray.
Thank you. Good morning, Mr. Gray. All right, we are here for sentencing today.
Yes, Your Honor. I've had the chance to review the PSIR with my client. Please let me know whenever you're ready for us to continue.
You said what? No, I didn't catch the,
Sorry, I know I usually, you usually say something before you usually ask if we've reviewed it with our client. We have reviewed the PSIR with our client.
all right. Are there any corrections, additions, or deletions?
I believe there's one part about his health. It mentioned needing surgery to remove a tumor. I would just correct that to say that he has a lesion on his knee and may need surgery. It's not cancerous. It's been found, he found out since the PSIR that it's not cancerous, but he still may need surgery on it. So that's the only correction. Other than that, Your Honor, we don't have any corrections, modifications, or deletions, but we would ask Your Honor not to follow the recommendation with regards to the jail time on this case. We understand the heaviness of this case. We understand how serious this case is. Mr. Gray understands that, you know, the actions that he took on that day led to this horrific, result. He understands the pain and the agony that he's caused. He's deeply, deeply regretful about this. He is absolutely taking responsibility for his actions that evening, Your Honor. He wants to pay for his actions. He's, going to do whatever Your Honor orders him to do. However, Your Honor, we don't believe that him going to jail would serve, any purpose of punishment in this case. We don't believe it would serve a retributive purpose. We don't believe it would serve any incapacitating purpose, a deterrent purpose, or even, a rehabilitative purpose. Mr. Gray hasn't missed a court date. He hasn't had any bond violations. He hasn't had a positive test. He tells me he hasn't drank since the day that this happened and never plans to drink ever again. He's been in constant contact with, I think, community corrections. He's been honest with Your Honor. He's been honest with probation. He was completely honest during his communication with regards to the PSIR. He does have serious health issues, Your Honor, and if it weren't for that, what we're saying here today would be different. But he has heart problems, and he just had an open heart surgery in December. He's still recovering from that. He just got cleared to work again. He will be taking medications. He has a lot of different medical appointments that he needs, both for his heart and for his lesion. I think he has lipedema in his legs as well. He needs to be exercising it. He needs to be doing his heart. He needs to be doing physical therapy. And again, potentially a surgery for his knee. We believe that, sending him to jail for a month, as the recommendation recommends, would set him back, for his ability to work. Because of his heart, he just got cleared to work. We would worry that would cause further delays in his ability to recover, his ability to work, his ability to pay
I'm sorry. There's a lot of Someone died.
I understand.
Go ahead.
And he wants to be able to pay the family the amount that is owed. He understands that that's not going to bring their son back. We know that that's not going to, change what happened, but the minimum he could do in this case is pay the restitution. And, being sent to jail is going to delay his ability to be able to pay that. It's going to delay his ability to complete any of the probationary terms, Your Honor. He wants to be able to do his community service and give back and, go to church. That's all he wants to do. He wants to work, he wants to go home and take care of his health. Again, deeply, deeply regretful of his actions. Every time we talk, our conversations are really long because he tells me about, his deep regret, his deep, how sorry he is, how badly he feels for the victim's family, how he wishes he could change what happened on that day. I was going to talk more about, his work and, how he's getting closer to being able to work, to be able to pay the restitution, but I won't go into that any further, Your Honor. We just wanted to say that he's deeply regretful. You can hear it from him himself.
Absolutely. Wish this would never happen.
It's not quite your time yet. I'll let you know when it is. Okay, sir? Thank you.
Nothing further, Your Honor.
You may have a seat.
Additions, corrections, deletions, Your Honor?
Yes.
Starting first with the spelling of the defendant's name. It's Allan on the first page, and on the third page, it's spelled En. It should be corrected to An.
Thank you. I'm gonna make that correction.
Thank you, Your Honor. On the first page, there's no victim listed. There was a victim in this case. His name was Dennis, Dennis. Last name Littlejohn. It's also on the complaint. That makes it easier for Your Honor to make sure that that's on the PSIR. The people would appreciate it if it was.
Thank you. I will certainly add the victim's name in this report.
Thank you, Your Honor. I have two more whenever the court's ready.
I am ready.
As to the recommendation, it does contemplate a term of jail in advance of a probationary term. So if the people would request that, condition complete MAD and victim impact data within 45 days of sentencing be modified to within 45 days of sentencing or release from jail. It doesn't seem realistic to have a 30-day or whatever jail sentence and then do the victim impact panel in a relatively short amount of time.
Okay.
As well as the next one, which is to enroll in complete cognitive behavioral therapy within 14 days of sentencing. That may be an impossible condition, so it should be within the date of sentencing or release from jail.
Thank you.
Those are the summary of my corrections and additions. I've had the opportunity to speak with DJ, that's Mr. Dennis Littlejohn, look like DJ, so that's the name the court will hear this morning, is DJ. I had a chance to speak with DJ's aunt Kelly this morning, who is here. She brought with her a celebration of life pamphlet and some photographs of the family. I've shown them to defense counsel, and she asked if the court would consider looking through them.
Thank you. Any objection? No objection, Your Honor. Yes, you may go.
I understand these photos are of different times that the family would like to go camping at Bishop Lake all together, and then the celebration of life pamphlet from the funeral.
Thank you. How long, please?
Yeah, take your time. Thank you, Your Honor.
Just a quick note for those of you listening on the podcast side, we have silence right now as Judge Washington is looking through information on the victim of this case.
Thank you. I have reviewed it.
Thank you, Your Honor. If it please the court, I'd like to save my comments on the recommendation till after the victim impact statements. Whoops. Thank you. First, we have 3 victim impact statements this morning, Your Honor. The first would be from Kelly Chin, DJ's aunt.
All right, thank you.
She's president of the Oh, does Carrie want to go first?
Ms. McQuaid.
Ms. McQuaid, Carrie McQuaid is DJ's mother. I'm not sure if she wanted to go first.
Good morning, Ms. McQuaid. If you want to go first, you can unmute at this time, state your name and begin your statement.
Good morning. My name is Carrie McQuaid. Okay. Good morning, Your Honor, and thank you for the opportunity to speak to you briefly about my son, Dennis. As everyone else knows him as DJ. On the morning of August 3rd, 2025, I was calling my son because I knew he had ran out of gas on the side of the freeway. And my last words to him were, please be careful. It's so dangerous and I love you. Something came over me, Your Honor, and I kept calling. I wasn't getting no answer until my son, Aaron, picked up his phone and notified me that Mr. Gray had hit my son. My son, Aaron, had to pick DJ out of the street while Mr. Gray sat in his car and offered no help. All he had to say was he was sorry and he fell asleep. Mr. Gray has single-handedly devastated me and my family. He has taken my son, my other kids' brothers. He's taken a dad, a nephew, a great friend, a great cousin. DJ had made some really poor decisions in his life. And he did his time and he came back a better man. He fought so hard to be accepted into society after going to prison. And he was. Mr. Gray took it upon himself to go to work and go and do whatever he had to do and go out and drink and fall asleep and decide to drive, which ultimately ended up with Mr. Gray hitting my son and causing his death. Since the beginning of all of this, it's always been, I've heard Mr. Gray health, Mr. Gray this, Mr. Gray that. It's been minimal about my son. I don't have my oldest son no more. I don't have the glue to my family no more. It has crushed us all. And I don't know how we're going to get over it. Because I'm forced to live this new normal without my son. Don't do nothing. I sit in my room day after day and cry and just look at his pictures and wonder why it had to be my son. All he was trying to do was get home, and he didn't make it. Your Honor, I am asking you to give Mr. Gray jail time. I understand that it will not bring my son back. However, it has to be a tone set for poor decision makings, especially when they end up in the court. Mr. Gray has taken my son away from me. He has taken my son away from his children and his siblings and his aunts. So, Your Honor, I am asking you to give Mr. Gray jail time. And if you don't feel that the maximum jail time is okay, then I would at least ask you to give him 18 days in Washtenaw County Jail. Because for 18 days, my son fought for his life until he couldn't fight no more. For 18 days, I had to sit there and watch my son wither away to nothing. And all Mr. Gray had to say was about his medical things that are wrong with him. I have things that are medically wrong with me as well, but I would never try to push it off as him. And I've always just heard Mr. Gray's health, Mr. Gray's heart. Mr. Gray is so sorry. Mr. Gray, I don't think did it on purpose, but he did it. And for that, there has to be some type of consequences for him. I appreciate your time. Thank you, Your Honor.
Thank you. I know how hard that must be, and I thank you. Thank you.
My name is Kelly Chen. I'm DJ's aunt. Carrie is my sister. And I wrote a statement today that I'd like to read. Please bear with me
Take your time.
if it takes a second. First, I would like to take a moment to thank you, Judge Washington, and the Washington County Court System for allowing me to speak on behalf of Dennis James Littlejohn, known as DJ to all who loved him. My name is Kelly, and I am proud to say I am DJ's aunt. Carrie is my sister. Words cannot express the loss suffered by so many, such as DJ's siblings, children, extended family, and friends, which include yet are far more than the names listed here. Carrie McQuaid, DJ's mother. Elaine Littlejohn, DJ's sister. Derica Littlejohn, DJ's sister. Aaron McQuaid, DJ's brother. Raheem Summers, DJ's brother. Malik Summers, DJ's brother. Malachi Littlejohn, DJ's son. Kari Littlejohn, DJ's daughter. DJ's nieces and nephews, Shania, Alea, Kamani, Marley, Mari, KK, Jamal. And this is only the immediate family. There are so many more extended family and friends that will forever feel the loss of such a bright light in this world. I would like to take a moment to speak on DJ's behalf. You see, like many of us, DJ learned things the hard way, causing him to be incarcerated for a total of 7 years. However, when DJ returned home, things were different. He knew that life in the streets was not the way to a good one. So he began to work and work and work, and then came Malachi, which made him work even harder, to be a good father and a friend. And when Kari, his daughter, came, it cemented the fact that DJ wanted to do better and be better for his family and friends. You see, DJ pushed people to do their best, to dare to dream of a better life. And he was taking everyone with him, always encouraging, saying, "We got this." DJ also chose to go to church and be saved. You see, DJ also spoke on the fact that he wanted his children to be raised right, so they would never put themselves in situations that could cause them harm or trouble. Here are some of the things we will miss about DJ. You see, DJ will never be there for another birthday, for his mother, his brothers, his sisters, his children, his friends. He will not be in any more camping trips to take the kiddos midnight fishing, which they all loved, or to yell out, "Last one down the hill is a rotten egg," to the kiddos, or watch his nieces and nephews and cousins and more play their school sports. DJ will not be there to take his daughter, Kari, to any daughter-daddy dances, or to teach Malachi how to throw a football or play basketball. I remember camping in 2025, DJ's son Malachi caught his first fish on a midnight fishing hike, and how excited he was. No more wagon rides, no more swimming, no more volleyball games with his cousins, to be continued because of the rain. As DJ would say, no more crazy Walmart trips for camping supplies. No more Christmases, no more Thanksgivings, no more Easters, no more New Year's, no more Halloween. It was heartbreaking when DJ's son said, "Can Daddy come home from heaven now? I want to go trick-or-treating." All taken away by Mr. Gray's action. Bad choices. Sakani, DJ's nephew, is due to arrive in May, born to his brother Raheem and his sister-in-law Coco. He will never know his uncle DJ. DJ's brother Aaron recently got married to his beautiful bride, Johnny, and DJ couldn't be there for that either. Nor did DJ get to see his children grow through school, be there for all the things dads are there for, all of the things that family and friends should get to share. No more of DJ's encouragement for any of us. You see, there are many crushed over the loss of DJ. We have all been given a life sentence without DJ, including the mother of his children, Gabby, who will now raise DJ's children, Malachi and Kari, without their father. And she has been assigned the task of explaining why Daddy never came home. You see, DJ's love was infectious and in such a way that you can never forget it. He had the ability to make people believe in themselves and strive to do better. and to be better human beings. DJ was always willing to help anyone in need, and the world definitely can use all the good it can get, all taken away due to poor choices Mr. Gray has made. I have watched my sister withdraw from life, lost and unsure. She has created a shrine in her room for her son DJ, which is where she spends most of her time, as this is where she feels closest to her son. No longer will his brothers and friends be able to throw a football, play basketball, barbecue, or just hang out. Again, because of Mr. Gray's poor choices. I have always told my boys, all three of them, in life, for every action there is a reaction. Whether it is good or bad is up to you, depending on the choices you make. And this brings me to Mr. Gray. I can say this, Mr. Gray, I forgive you for being the cause of my nephew DJ's death. You see, forgiveness is for me, not for Mr. Gray. I refuse to hold animosity in my heart. However, make no mistake, I will never, ever forget what Mr. Gray did. When he so carelessly took my nephew DJ from all of us, this entire situation has changed our family forever. I do hear Mr. Gray speak often about delays due to his health issues, whatever they may be. However, my sister too has health issues. She has stage 3 CKD, which is chronic kidney disease. She has beat cancer once, and we are hopeful that she will beat it again, because she has it again, as well as a slew of other health issues. The latest being severe depression and stress, which are horrible for my sister's CKD. Yet she shows up every time, as she always has in life. It is my opinion that the state of someone's health should have no bearing on the outcome today, as I am aware that there is health care for those incarcerated, and Mr. Gray's health is not out here for sentencing today. The act that Mr. Gray chose to commit, which is driving while sluggish, groggy, or any other word that may be used to excuse Mr. Gray's actions, which is what is on here for sentencing today. All the police report shows is a lower level of alcohol, apparently under the legal limit. Also shows that Mr. Gray failed every other roadside sobriety test. That being said, it is my hope today that Mr. Gray received the maximum amount of jail time by law, as all of DJ's loved ones have received a life sentence without him. In addition, it is my hope that Mr. Gray will pay restitution for the funeral and all the expenses that DJ's death cost. There is no price tag big enough to put on a human life. Mr. Gray has taken away my sister's son, DJ. Sorry. And forever stolen a piece of many people's hearts. You see, I cannot hate Mr. Gray, as I do not even know him. However, I can hate the act that Mr. Gray committed against my nephew DJ and his family, whether intentional or not. Mr. Gray knew he had been drinking or reportedly taken narcotics for pain, although Mr. Gray did state he did not take them that day. And only he knows the truth in that. It appears to me in each court appointment, I have watched it become about Mr. Gray's health, which is not on track here for sentencing today. And I feel it is an attempt to get a reduced sentence or no sentence at all. What message would that send to the masses? Whether we call it murder, involuntary manslaughter, careless driving, the end result remains the same. Dennis James Littlejohn is no longer with us, lost at the young age of 30 years old. And it is my hope that justice will be served. Justice will be served. I am hoping to have some closure for my sister and her family, knowing that justice has been served. You see, nothing Mr. Gray can ever say will change what he did. He killed my nephew DJ because he chose to get behind the wheel while in an unsafe condition, sleepy, so he says. And to me, that is an unacceptable response. You see, Your Honor, this is not the first time this has happened to our family. My mother was hit by a car and killed at the young age of 38 years old. And this tragedy has reopened old wounds. And we are reminded of how losing a loved one so carelessly affects the entire family forever. Left to try to learn how to cope, to find a reason to smile again and carry on with life. And there is no sentence greater than that of losing a loved one, especially in a family as close-knit as ours. You see, DJ touched the lives of all that he met. He had a heart bigger than the Grand Canyon, a character that made us laugh, made us believe in life and the fact that it could be better, and the drive to succeed, to surpass all of his own expectations, and to teach others to do the same. DJ's irreplaceable and will forever be missed in all we do. In closing, again, I'd like to thank Judge Washington and the Washtenaw County Courts for allowing me to speak on behalf of my nephew DJ, who cannot be here to speak on his own, although he is here. It is my hope that justice will be served here today with the maximum imposable sentence allowed for Mr. Gray. I pray that this incident and the death of Dennis James Littlejohn that Mr. Gray has caused remains in the forefront of his mind each and every day, especially every time he gets into a vehicle for the rest of his life. You see, DJ was not given that option as Mr. Gray took that away. Thank you for opportunity to speak. And you've already got my pictures.
Thank you.
Thank you.
We have just one moment, please, Your Honor. Yes. Okay. I think we're not gonna have any more statements from, change of plans. The people would ask that the court adopt the recommendation. Commission has prepared. I have nothing. Thank you.
You may return to the podium.
Thank you.
Anything you'd like to say before I go to your client?
Nothing further from you.
Mr. Gray. Now is your opportunity to speak. And the reason you do that is because it's important for you to hear from the family before you get a chance to speak. What you have to say today is very important for them and very important for me. Very important for you and very important for the whole community for that matter.
I'm deeply, I can't say how sorry I am. Wish this would never happen. Because when I walked out my door on the second, evening to go out, I would have grabbed myself and said, your life's gonna change forever. I drug myself back in and bid back for mercy of the family. I'm beyond sorry. I can't say sorry enough. If his mother was standing here, I'd kiss her feet. I'm beyond, I'll live with this for the rest of my life. I'm remorseful. I'll be in repentance for her forever. I beg for mercy. Beg for mercy. I'm beyond sorry and apologize. So sorry. Please forgive me, please. Beg for mercy. Sorry. I know how much my mom loved me, and I know how much I love my mother. Just said I can't say no. I can't say sorry enough. I'll be sorry forever and ever.
This particular case is extremely challenging. Some judges take the time and sit down and they write a statement that they're going to say at occasions like this. I choose not to do that because I want to hear what everybody has to say and I want to respond directly to that. To you, to the family, to his mother. I think the defense said that this case is extremely heavy, and it is. Any time when life is lost, it's extremely heavy. When a young life is lost, it's even heavier. When you have someone who is so connected to so many people, it's beyond words. And I knew today was going to be heavy. But it's heavier than I could have imagined, to be honest. No matter what I do today, it's not going to bring their loved one back. It's not going to make their life the same again. That's never gonna happen. Because like they said, it was your choices that day. And it wasn't just one choice. As I read through the report, it was a multitude of choices. You took Norco earlier in the day. You drank. You went and hung out with a friend. You left at 4 a.m. in the morning. None of those choices were the right ones. Obvious. Our society is guided by the laws. The laws say that in this particular case, you're charged with a misdemeanor. So you're in misdemeanor court, where the maximum penalty for this offense is 1 year. I couldn't do any more than that if I wanted to. The other problem is if you do 1 year, then there's no probation. Because you can't give somebody the entire sentence and then put them on probation too. I don't look at this as just a punishment. I gotta look at the actions that you did take. And fashion a sentence that takes that into consideration. The problem is, there's no sentence that fixes this. It just can't be done. This is hard, and you caused it. It's my job to come up with what's best. My problem with you is not every choice that you've made since then, but as I read through your statement and I listened to what your attorney has to say, the family's correct. It's a whole bunch of you, and your health. And I'm not suggesting that I don't take that into consideration, but this is not all about your health. There is medical treatment in the jail. It is not the same as outside of the jail. And I know that because I've been a part of the system for a long time. So I don't want this to be a death sentence for you too. I'm concerned about that. But the bottom line is, I quite frankly think that the recommendation is appropriate. I considered more time. And I had to think about whether I wanted to give you more time because I'm angry or because I think it's the right thing to do. And as I think about it, I think it's because I'm angry and I'm paying for the family. But that's not the job I have. The job is to do what I think is, in terms of right, what the consequences should really be. Mom has said that, 18 days. 18 days, she watched her baby. Basically, 18 days. She watched him leave this life. There's nothing I can do that can fix that. I have to take into consideration your past record and the actions of that day to come up with the right sentence. And what I think of as your level of remorse, and I get that you are remorseful in the sense that you're sorry, but sorry can't fix this. And I'm going to follow the recommendation. I'm going to impose sentence at this time. It is the sentence of the court that you serve 365 days in the Washtenaw County Jail. Credit for 0 days served. You're going to serve 30 days in the Washtenaw County Jail. The 335 are suspended. And they're suspended as long as you do what you're supposed to do. If you don't, then I'm just going to give you the full sentence. I know it doesn't sound to you like it's fair. There is no fairness in this at this point. You're on probation for 24 months. There is no early discharge. You're to complete 400 hours of community service at a location chosen by the victim's family. I understand that there's a pending lawsuit at this time regarding the restitution.
I don't think that the pending wrongful death suit includes the restitution amount, Your Honor. It's my understanding, and we can talk about this more if it helps later, but I think that the wrongful death suit has been brought by the mother of the children, and the restitution amount contemplates the funeral costs borne by Ms. McQuaid.
Gotcha.
Yes, that's my understanding. So I do think the restitution amount is not subsumed by the
Yeah, I believe that's true, and the suit is not pending.
It's my understanding that we can talk about this more if it's
I'm sorry, I didn't catch that, Ms. McQuaid. I'm sorry. Go ahead and say that again, please, if you have.
and the restitution amount contemplates the funeral costs borne by Ms. McQuaid. Yes, that's my understanding. So I do think the restitution amount is not subsumed by us. I believe that's true, and the suit.
I'll just leave it. It's just the feedback from what the prosecutor was saying, so.
Is she listening through YouTube? So it may be delayed. If we can wait.
Excuse me, can you hear me?
Yes, ma'am.
Hello?
Yes, ma'am.
Okay, the cost for the funeral was not included in Gabriella's lawsuit. That's why I asked for the restitution for the funeral cost, which was $5,500 for 3 hours.
All right, thank you so much.
Thank you.
Any additional $400-ish, Your Honor, come from the cost of printing the pamphlets, materials.
Restitution in the amount of $5,925.60. Fines and costs in this case for a total of $725. $30 per month probation oversight fee. You to report to the probation officer monthly via the online reporting platform and report to probation during the second week of each month. I'm going to change that wording to make it read month, by the way. And report to probation when and where directed, including any and all home visits. To complete the jail John Farms program while in custody. You to complete the ABR Level 2 driver rehab course. You to complete the MAD Victim Impact Panel within 45 days of release from custody. You to enroll in and complete the cognitive behavioral therapy program approved by this court within 14 days of sentencing or release from custody. So it'll be for release from custody. You'll follow all recommendations made and sign a release of information for the probation department. There's no use or possession of alcohol, marijuana, illegal drugs, drug paraphernalia, firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone carrying or using those. You will drug and alcohol test 1 time per month as ordered by the court, probation, or police. There'll be a review in front of me in 90 days. That's going to be on June 11th, 2026. And that'll be at 10 o'clock p.m. Would council approach, please?
Again, for those of you listening on the podcast side, the silence we have right now is as judge is conferring with counsel at the bench. So give it just a minute.
Hold on, please.
Again, for those of you on the podcast side, looks like Judge was reviewing something. Should be back with us here in a moment.
So,
Apologies, guys. I stepped away for a moment. She did cut the feed, but I think we got the gist of it. We know what went down there. Good morning once again, everybody. TCF Live. It is a Friday. Yeah, we stumbled into a heavy start to the day. So let's take a breath. There's the Ellie cam. Ellie knows how to chill, so let's all take her lead on that one. All right. Let's do this. Let's change up the tone. Let's go down to Florida. Wade Mercer.
Mr. Baxley, good morning. Mr. Baxley, you're here because you've been accused of one count of battery. Mr. Baxley, I read the complaint. I wasn't sure about probable cause, but I did a little research this morning, and based upon the case law, it appears that there's probable cause. Mr. McNally, would you like to be heard on that?
I think it's it's a very close call, and I think you're going to rule that it's probable cause, so I'm not going to argue. Was he forcibly taking it from her? He just took it it's a close call, and I think it'd be, whatever Your Honor wants to do.
Thank you. Mr. Mitchell, anything?
No, Your Honor.
So, Mr. Baxley, I'm going to find there is probable cause based upon the case law provided to the attorneys this morning. Mr. Baxley, your mother's in the courtroom. Ma'am, do you want to be heard? You want anything you want to say on the record, ma'am? Is there anything you want to say? If there is, I need you to come up here to the microphone so he can hear you. Right here, ma'am. So come on up. And this is Miss Baxley, correct? I'm going to get you to raise your right hand, your other hand.
Oh.
It's okay. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but truth to help you God.
Yes, I do.
Okay. You're his mother and you're the alleged victim, right? The alleged victim, that means they're the ones that they're saying that the phone was taken out of your hand and that he's been charged with battery, but is there something you want to tell us?
Yeah.
Okay.
Josh didn't mean to take the phone. He thought I was talking to the real estate lady, and he's got it in his head that we're not being evicted because he is FBI and he's active duty. So he's got in his mind that we're not being evicted. And he didn't want me to talk to the real estate lady. I was talking to Michael. And that's when he took the phone from me and tried to hang it up.
Michael's your stepson.
Mm-hmm.
Okay.
And try to hang it up. And I told him, I said, give me my phone. And he walked a couple steps back and put it in and threw it on the couch.
Okay. The complaint says that this is a reoccurring issue, that one time they took your phone for a week.
Yeah.
Okay. So what are you asking us to do today? What we do to help the situation?
I want him to get some help. I didn't want him in jail. Never want him in jail. But I want him to get some mental help or help he needs to be a survivor, Okay.
I intend to order no physical contact, at least temporarily, with you. Okay. My question for you is, do you want to have telephone contact with Josh while you work through this, or do you want no contact at all?
I want contact.
Okay. Understand, I'm going to do no physical contact, at least until his court date, and we see what happens. But I'm not going to stop all contact based on what you're telling me today. You understand?
He's going to court? Is he gonna have to go to court?
Mr. Mitchell's office will review this case, and if they decide to charge him, then yes. Well, we're gonna give him a court date today. And unless they dismiss the case, he will have to come to court. And if you think about it, the goal is not to put him in jail. The goal is not to put him on probation necessarily. The goal is to try to accomplish what you're asking for, which is to get him some help. So as part of any release, I'm going to require him to go through a mental health evaluation.
Yeah.
That's what you're asking for.
That's what I'm asking for.
Mr. Mitchell, any questions of Ms. Paxley?
None on record. I'll ask her one as she passes by.
Thank you. Mr. McDaniel, any questions for Ms. Paxley?
No, Your Honor.
All right. Thank you, ma'am, for being here. And Mr. McDaniel, I believe your text says that he does have somewhere else he can go on a temporary basis.
Yeah, he can go to his brother's in Compton.
Okay. You can have a seat back, ma'am.
I can, put him in a, motel room if that.
Well, no, I mean, you don't want him in jail. He has no history. No history, right, Mr. McDaniel?
Correct, no history.
Okay, so, I mean, we're gonna get him out. It's just, I need to get him out and I need to make sure he's got a place to go. So
Get him out and not me having contact. He's wanting to go back to college because he said he's wanting to do, physical therapy. If he goes back to college, this will be on his record.
the arrest will be on his record unless it's expunged, and he may be able to get it expunged if it's dismissed. So you can have a seat back in the audience,
Thank you,
okay?
sir.
Thank you. So,
My dad was
Mr.
active.
I'm sorry, I couldn't hear you, Mr. Baxter. Say again.
I said my dad was active duty, sir. That's why I said that.
I knew your dad. Your dad coached baseball in Grand Ridge. He coached the Lions, and they used to beat us pretty bad. I played for the JCs, but your brothers both played for the Lions. So I don't know you, but I know your dad fairly well. So Mr. McDaniel, Mr. Mitchell, let me wait till Mr. Mitchell gets through speaking. Take your time. I know you.
What was it, Your Honor?
Any other input? It's okay.
No, Your Honor.
I'm gonna let you pick between the bond and the conditional release. If you'd like to post the bond is $2,500 cash or surety. I'm gonna offer you a conditional release because you've got no history, Mr. Baxley. Mr. Baxley, you will have a condition to do a mental health evaluation and follow the recommended course of treatment. If they evaluate you, the professional says you don't need any treatment, that's great. If they evaluate you and say that you need to go on some medicine or they recommend some type of counseling, you've got to go to that recommendation, Mr. Baxley. So the conditional release office will explain that to you if you choose the conditional release. The only other condition is no in-person contact with your mother. I intend for that to be a very short-term, temporary condition. If she wants contact, Mr. Baxley, and if you want contact, then I'm probably going to grant that. I'm going to listen to the state before I do so. But for, at least for the next week or two, I'm going to order no contact, at least until your court date. Mr. Baxley, do you understand the difference between the bond and the conditional release?
Yes, Your Honor.
And which one do you prefer, Mr. Baxley?
Conditional release.
I'm going to grant you the conditional release. So here's what's going to happen next. Mr. Baxley, they're going to let you use the phone. And the reason for that is so you can set up transportation. You can contact your friends or family for purposes of transportation. Then they're going to bring you to the courthouse. That will be roughly 30 to 45 minutes from now. So if someone picks you up, they can pick you up at the courthouse in 30 to 45 minutes. The other thing they're going to do is give you a notice for your court date, which will be when?
30th.
March the 30th. You can have telephone contact or electronic communication with your mother. Just no physical contact, at least for the time being, like I've explained. And when you get here, the conditional release officer will talk to you and explain more about the mental health evaluation. Let's make sure you're doing good. Mr. Baxley, do you have any questions?
No, Your Honor. Thank you very much.
You're welcome. Ma'am, do you have any questions?
Yeah, I think Michael's out of town because he said he had to go out of town today, but it was going to be released in 30 minutes.
I couldn't hear you. Say that again, ma'am.
If he was going to be released in 30 minutes, Michael can't pick him up.
Okay.
My mom's going to have to pick me up. Well, can I call Uber, maybe DoorDash, somebody? Uber?
Are you comfortable? I just want to keep the peace, ma'am. That's what I'm trying to do. So are you comfortable? Are you comfortable picking him up and taking him to Michael's? Or you'd rather make him get somebody else to do that? So you'd rather do that than pay an Uber or go through that? And you don't feel endangered or, he allegedly grabbed your phone. He didn't strike you or kick you or hit you. That's what it's accused of. Okay, Mr. Mitchell, what's your thoughts about me allowing contact for today, physical contact for today only, and then giving a cooling off period once she gets him to wherever he's going to go?
I have no problem with that. No objection.
Is that what you want to do, ma'am?
Yeah.
Okay, so I'm gonna make an exception for today. I'm gonna let her get you to where you need to go, Mr. Baxley, and then y'all kind of a few weeks apart may put things in a better perspective. So that no contact condition will start tomorrow, so you can pick him up today, okay? So it's usually about 30 to 45 minutes from now before he gets to the courthouse and gets instructed. He'll be downstairs in the probation office in roughly 45 minutes. 30 to 45 minutes, okay? All right, thank you, ma'am. Mr. Baxter, wish you the best.
Thank you, sir.
Yes, ma'am. We've had some more people come in for first appearances. Mr. McDaniel, are y'all here for a first appearance case? What case is that? And do you want Mr. Johnson to know that you're here? And your family? Mother? Elijah Johnson? Johnson, good morning. Your mother and a couple of other friends or family members are in the courtroom. Mr. Johnson, you're here for 3 charges. You've been accused of 1 count of fleeing or attempting to elude law enforcement, 1 count of tampering with evidence, and 1 count of possession of marijuana over 20 grams. There's probable cause for the first 2 charges. On the 3rd charge, I'm not sure there's probable cause yet, based upon the officer not putting any type of field test result in the complaint. Mr. Mitchell, anything on that?
So, Your Honor, I spoke to Deputy Mathis today. He said that he based his finding that it was marijuana or cannabis based on the labels that were on the bags and the containers, which said that it was cannabis, a Schedule 1 controlled substance. He also based his findings on Mr. Johnson saying that he had been smoking weed prior to having contact with law enforcement. So they used those articulable suspicions to find that it was cannabis and that it was weed in that manner. Deputy Mathis did say they thought they run a field test kit, but he couldn't remember at the time.
So him saying he has smoked weed is not helpful at all, because he denied ownership of this substance that was found outside the car in the ditch or in the woods somewhere. So that doesn't help us. As far as the packaging, I don't remember that.
So it's in the 3rd page, 3rd paragraph, where it says 2 jars labeled Stellar Snow Caps, each containing approximately 29 grams of a green leafy substance coated in white crystalline substance. The label on the back of the Stellar Snow Caps jars contain a government warning stating this product contains cannabis, a Schedule 1 controlled substance.
And that was in the bag that was found?
Yes.
Okay. Mr. McDaniel, I think that may be enough for probable cause. Anything, Mr. McDaniel? I did not catch that. Anything from the defense?
I mean, was it a sealed bag? I mean, I guess, was it never opened, government sealed, or, I mean, I don't know if.
It says vacuum sealed plastic bag.
That's a close call.
For probable cause, I'm going to find it's close enough for probable cause. It certainly doesn't mean that you're guilty of anything, Mr. Johnson. It certainly means that there's enough evidence to justify you being arrested and charged, especially with the fleeing and eluding, the running through the woods and so forth. There's plenty of evidence there to justify me setting you a bond. And rather than hold you 24 hours and give them time to amend, I'd rather go ahead and set you a bond today if there's probable cause, of course. So I'm going to set you a bond in these cases. Mr. Johnson, I saw little or no prior criminal history. Have you ever been arrested or charged with a crime, Mr. Johnson?
Yes, sir. When I was a lot younger, I did get charged, but it was like a misdemeanor.
Was it a juvenile charge?
I think it was.
I think it was a juvenile charge when I was like 19.
Okay, that's not gonna, well, yeah, there's nothing on your history. So the other question I have is that the pretrial release information says you're 21 and you have no job. Are you a student?
Nah, I'm not a student. Now I'm getting ready to go. I was trying to get a job over here in at BTC in Panama City. I was waiting on them.
Okay, how long has it been since you had a job?
Not that long. I was working with this guy in Panama City. Like, I go down there, we build houses and stuff like that, remodel and stuff, construction.
Okay.
His name is Mr. Sam. He got a business.
Let me see if Mr. Mitchell or Mr. McDaniel have any additional information before I set your bond. Mr. Mitchell, anything?
No, Your Honor, we just request he be subject to random UAs as a condition of his bond.
Thank you. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Johnson, I'm going to set your bond at $5,000 on the fleeing and eluding, $5,000 on the tampering, and $7,500 on the marijuana because of the huge amount of marijuana that was found. Your total bond is $17,500. Cash or surety. So what that means is that he does not have to post all $17,500. That's not what it means. Cash or surety means you can go through a bondsman, and the bondsman by law has to charge you 10%. But what most of them will do is they will negotiate. They will take some upfront and some monthly payments. I know he has no history, but the two problems are allegedly he ran from police and wrecked the car, and then got out of the car and ran to the woods. So that's why he's getting the bond, even with no history. And then the other factor is it was a lot of marijuana. It wasn't an amount that's consistent with personal use. It was a lot. It was 500 grams. It was a lot. That's a lot of marijuana. I see, 5 grams or 2 grams. I see that all the time. 500 grams. I probably haven't seen marijuana that big in a year. Okay. So, Mr. Johnson, I was just explaining to your mom why you're getting the bond that you're getting. Do you have any questions, Mr. Johnson?
No, sir. Is my mom? You said my mom's there?
Yes, your mom is in the courtroom. Yes, sir. And a couple of other friends or family member are with her.
Okay, then.
Well,
Yes, sir.
yeah, I'm
And
sorry.
You said my cash
Hang on,
bond.
just a second. Just a second. One of them said something. Your mom and your aunt and your mom, your aunt, your girlfriend, and your daughter are in the courtroom. That's the people that are here. Did you have another question, Mr. Johnson?
You said my mom, my daughter, and my
Girlfriend.
mom, my
and
daughter,
your
my
aunt.
auntie, and my girlfriend.
Yes, your girlfriend's here.
Yes, sir.
All right. Any questions, ladies?
Tell them I'm gonna call them if that's okay.
You certainly can do that. You'll get a chance to use the phone in just a few minutes. Your mom was saying something, ma'am.
Yes, sir.
Come on up, ma'am. It's okay. I want to make sure that Mr. McDaniel can hear you too, because sometimes Mr. McDaniel will ask for a cash bond. Okay, so you were asking a question about the 17.5.
Right. So with that being said, now for the 10%, so how much would I owe with just being 10% if I wanted to go down there and get it out with cash?
If you go to a bondsman and they charge you the full 10% up front, that's $1,750.
Right.
The
Okay.
bondsman may say, we'll take half of that up front and you pay us X amount of dollars per month.
Okay.
If you know that you can post the $1,750, you may prefer a cash bond.
Okay.
And here's why. If you give the $1,750 to a bondsman, then it's spent. You do not get that back.
Right.
If you have the $1,750 and you give it in the form of a cash bond, it's held by the clerk's office until the case is over. If the case against him was dismissed, it's returned to whoever posted it. All of it.
Okay.
If on the other hand, if it's not dismissed and he enters a plea and there's court costs and fines, it has to go towards court costs and fines, and then any left over then gets returned to whoever posted it.
Okay.
So if you know that you can post the $1,750, then you may want to post a cash bond. On the other hand, if you don't know that you can post that and you want to talk to a bondsman about payments, you want to choose the surety bond.
Okay.
So you want to talk to a bondsman? Is that what you want to do?
I think so. I got some of the money. I don't have the whole $1,750.
Mr. Mitchell, is there any objection to me giving her that option of a $1,750 cash bond under these circumstances?
I was about to say, I have no objection to giving her the option in that situation where we set it both as a surety bond and or a cash bond.
Mr. McDaniel, you okay with that?
Absolutely.
So what that means is I'm going to go ahead and give y'all the choice now. So if you come up with $1,750, that may be the better bet. And he can talk to Mr. McDaniel after court about why that may be the better. I kind of explained a little bit, but the big difference is if the case against him is dismissed, it gets returned. That's not true with the surety bond. If you pay a bondsman the fee, that's their fee. They're entitled to it because they're vouching for his appearance. And if he doesn't show up in court, they have to pay. Okay. So it's $1,750 cash only, or if you want to go to a bondsman, it's $17,500 bond. So it's probably going to cost you $1,750 either way. It's just one of them you may be able to make payments.
Right.
Okay. Have you read the complaint? You probably haven't read the complaint.
I read it.
Okay, so you know what the allegations are. Okay.
I read it.
You have any questions? All right, thank you for coming.
Mhm.
You have a question, ma'am?
Yes, sir. As far as I'm concerned, it said that he had 20 grams of possession.
I was about to say,
I can't understand what she said. What's she saying?
she's talking about the facts of the case, and that situation might not be the best time to talk about that. Wait until he's appointed a lawyer and he can talk with his lawyer on that one.
Yeah. And there's significant evidence against him. I'll put it like that. There's a very strong case on the fleeing and eluding. The marijuana's not near as strong, but there's a pretty significant case based upon the recent rain, the dryness of the bag, the location of the bag, him running, him coming back. There's just significant evidence that marijuana was his. Now, can they prove it to a jury? Who knows? All right. All right. Wish you the best. Thank you. We do need to give him a court date for April 7th, please, at 8:30. Ladies, his court date will be April 7th at 8:30 in the other courtroom. Okay. Thank you. Mr. McDaniel, that takes care of the cases we have friends or family here for. So let me go back to the top of the list, which would be Kenwin Printup.
So while we're waiting for the next contestant to come up there, I am kind of looking at Judge DeSanto's courtroom at the moment. She is getting ready for a trial. She's reading through boilerplate instructions and whatnot for the jury. So I got no idea what's going on there or what it's about. That's why I asked you in the chat if you'd be interested. So I'm going to try to figure out what this is about once she gets past all this boilerplate stuff, and then we'll go from there.
But I'll leave it up to the court.
Can they search? Okay, searches on.
Mr. Mitchell, the firearm, that statute says display. We had the same statute yesterday.
Yeah.
It says use, display, or carries. In this case, I found probable cause before. If it's on the pocket or in their hand, obviously that's carrying. That's enough for probable cause. I think we had one this week where it was under a driver's seat, which I found was sufficient. And we had one where it was in the trunk, and I found that was insufficient, or in the back seat. I said that's not enough for probable cause for carrying.
Mm-hmm.
And this officer charged him with using, display, or carrying for a firearm that was under the passenger seat. So it's. What's your input?
It's this is like the third different agency that is also.
I don't know if I can prove that to a jury that that's carrying, but it may be enough for probable cause and me set a lower bond than normal.
I have no objection to that.
So Mr. McDaniel, I'm going to compromise. I frankly don't know that they can convince a jury something under a passenger seat is carrying, but the statute doesn't define carrying. That's the problem. I'm going to find probable cause. I'm going to give an ROR on that count.
I also argue, beyond just that statute there, it's during the commission of a felony. And just because you got, your possession is not, that's not in the commission. It's meant to be in the commission if you're doing something, a violent felony or something, not just, so if you got charged with, some other charges, felony charge of, we got one today of contracting without license, and it's a felony charge. It had a gun in the car. Is that logically? It's during the commission of a crime, but I'll leave it to the court.
I don't disagree with your statement. But the problem is the wording of the statute doesn't say that. It's just, it could be better written to make our lives easier, but it's not. So what I'm going to do is find probable cause for that charge. I'm going to give an RO on that charge. That does leave the other two charges, which are possession of marijuana more than 20 grams and possession of paraphernalia. Anything you'd like to be heard on those two charges, Mr. McDaniel, regarding bond or anything else?
No, Your Honor.
This was 34.5 grams compared to 500 in the last case. Mr. Mitchell, anything?
We just, regardless, request he be subject to random UAs.
And in your case, Mr. Printup, you have no prior criminal history also, is that right?
Yes, sir.
It's a lot closer case for the difference between bond and conditional release, much closer analysis than the last case. They both have no prior criminal history, but it's a tenth, less than a tenth of the amount of marijuana in this case. Mr. Mitchell, what's your position on bond versus release? Let me ask him a question first.
No preference really here.
Mr. Printup, your pretrial release sheet says no employment. Are you in school? Or are you working or neither?
No, I was at school at Dalton State.
You're a college student?
Yes, sir.
Are you full-time? Full-time?
Yes, sir. Yes, sir.
Okay. That helps. Mr. Mitchell, anything?
No, Your Honor.
Mr. McDaniel, anything else?
Nothing, that's Sean.
Mr. Printup, I'm going to let you pick between the bond and the conditional release for the variety of reasons I've kind of covered on the record. If you want to post the bond, your bond's going to be $5,000 on the felony, $2,500 on the misdemeanor. That's $7,500 total. If you want to accept the conditional release, I'm going to offer you a conditional release because of your lack of history and your full-time college student status. Mr. Printup, do you understand your choice between the bond and the conditional release?
What would be the difference?
Did you say conditional release?
Yes, Your Honor.
I'm gonna grant you the conditional release. You will have a condition random urinalysis. I did put that on the last gentleman, didn't I?
Yes, you do.
You have a condition random urinalysis and the standard conditions of conditional release. And what's going to happen is you're going to get to use the phone, then you're going to be brought to the courthouse. You'll be free to be picked up at the courthouse in 30 to 45 minutes. And we're also going to give you a notice for your court date, which will be April the 7th at 8:30 will be your court date. Do you have any questions, Mr. Printup?
I don't live in Jackson County, so I would have to commute for my court date?
Yeah, you got to commute for a couple of days.
On the court date, you will. Now, during the conditional release, those are weekly telephone calls. They're by telephone, but on the court dates, it will be in person. Yes, sir. Okay. Have a good day, sir. Mr. Carter, have you been there logged?
Barbara, thank you for the $10. Very much appreciated. Super chat on a super Friday. Thank you so much.
And that is State of Florida versus Lorenzo Macario.
Bien,
Mr. Carter, if you'd introduce yourself, please, to him and make sure he can hear you.
Buenos días, señor Macario. Mi nombre es Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Me escucha bien?
Sí, buenos días.
He can hear me, Your Honor.
Mr. Macario, you're here because you've been accused of one count of driving with no valid commercial driver's license.
Señor Macario, usted está aquí porque tiene un cargo de manejar sin licencia de conducir comercial.
In addition, you have a detainer from the United States Immigration Service.
Adicionalmente, tiene una orden de retención de parte del Servicio de Inmigración de los Estados Unidos.
I'm appointing the public defender's office to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Le voy a asignar al abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I've spoken to Mr. Macario. He's going to plead no contest to the charges as listed. The understanding he'll be sentenced to 2 days in jail, credit for 2 days, and a $400 fine.
Su señoría, he hablado con el señor Macario. Él se va a declarar no me opongo ante la acusación, así como aparece, entendiendo que se le va a condenar a 2 días con crédito por los 2 días ya cumplidos y tendrá una multa de $400.
Waived his right to a jury trial and call witnesses at that trial and understands that any conviction can result in deportation.
Él ha renunciado a su derecho a un juicio y a llamar a testigos en dicho juicio y entiende que cualquier condena puede resultar en la deportación.
Thank you. And Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Gracias. Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Macario, did you hear that agreement?
Señor Macario, ¿escuchó usted el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No.
No, nothing.
Is that the plea you would like to enter to resolve this charge?
¿Es este el acuerdo que desea aceptar para resolver el cargo?
Sí.
Yeah.
I'm going to accept your plea of no contest to the charge of driving with no valid CDL driver's license.
Acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir comercial.
I'm going to withhold adjudication of guilt and sentence you to 2 days in jail.
Le voy a suspender el fallo de culpabilidad y lo condeno a 2 días en la cárcel.
And I'm going to give you credit for the 2 days you've already served.
Y le voy a dar crédito por los 2 días que ya ha cumplido. Okay.
So what's going to happen next is the jail is going to notify the Immigration Service that you resolved your local charges.
Lo que va a pasar después es que la cárcel le va a notificar a Inmigración que usted ha resuelto sus cargos locales.
And they will pick you up, and that's typically within 2 working days.
Y ellos lo recogen normalmente dentro de 2 días hábiles.
Let me clarify that. Corporal, is it 2 working days or is it 48 hours? Today's Friday.
48 hours. 48 hours. They come pretty like, they're up here every day, so it's.
So they'll pick you up within 48 hours.
Bien, entonces lo van a recoger en un plazo de 48 horas.
Do you have any questions?
¿Tiene alguna pregunta?
No.
No.
Have a good day, sir.
Que tenga buen día, señor. Thank you.
Thank you. And Mr. Ricardo, thank you. Mr. Goodson said hasta luego.
Thank you, Your Honor. Bye-bye.
Bye-bye. Next, we have John Burrows.
Only his best and most fluent Spanish.
An interpreter. We have another interpreter. He called Mr. Goodson the other day, asking him a question about how to pronounce something. So very helpful. Mr. Burrows, good morning. Mr. Burrows, you're here because you've been accused of one count of eluding lascivious exhibition. That is a second-degree felony, and you've also been accused of one count of prohibited device usage. That's using a computer in certain unlawful ways. That's a third-degree felony. Mr. Burrows, there is probable cause for both charges. I'm going to appoint the public defender's officer to represent you. I'm going to listen to the attorneys before I address your bond status. Mr. McDaniel.
Yes, nothing. We don't have anything. I'm just asking for reason bond.
Thank you. Mr. Mitchell.
Your Honor, I was in touch with the investigator that sent in the complaint and brought the charges. He said that there is a possibility that there may be more serious charges coming regarding the same defendant. I just wanted to bring that to the court's attention and also to his attention also.
Did late yesterday, I had a conversation with a captain. Did that person make you aware that there were some potential evidentiary inconsistencies in those other charges?
I was not aware of that, no.
Yeah, pretty significant inconsistencies regarding the tattoo and the absence of a tattoo.
I was not aware of that.
So for today's purposes, I'm going to assume there are no other charges based upon the information I have. If they do charge you with something else, Mr. Burrows, then we'll deal with that if it comes up. It may or may not be a result in another bond. But for today's purposes, what we've got are these two charges, a second-degree felony and a third-degree felony. I'm going to set your bond at $15,000 on the second-degree lewd and lascivious, $5,000 on the computer charge. Your total bond, Mr. Burrows, is $20,000 cash or surety. Mr. McDaniel, I'm assuming you're requesting some type of limitation on contact with minors. Is that right?
You mean?
I said Mr. McDaniel. Mr. McDaniel's not requesting that. Mr. Mitchell's requesting that.
Yes, Your Honor. At least, no, I know it's computer usage. I'm trying to think of the best way to word this, but
one part of it's not computer usage at all.
Well, yeah, I know. Sorry, misspoke. No, I guess no unsupervised contact with minors.
Mr. McDaniel, thank you, Mr. Mitchell. Mr. McDaniel, I'm always kind of hesitant to delve off into that without getting some input from counsel. The request is no unsupervised contact with minors, but if he's got minors, you're okay with that? If it's worded that way, I don't want to put him in a bind with his own children or something necessarily.
I don't think that's an issue, Your Honor, so we don't have.
All right, so I'm going to have a condition of no unsupervised contact with minors. Unsupervised. And when I say unsupervised, that means there has to be a person there that's aware of, that's in charge of the care and custody of the child and is also aware of the allegations against you or the pending charges. So, Mr. Burrows, you have the right to post a bond, sir. You'll use the phone in just a few minutes, sir, to try to post that bond. The jail will give you a notice for your court date. It should be April the 7th at 8:30 a.m. Mr. Burrows, do you have any questions? I wish you the best, sir. Next case we have is Danielle Sellers. I said 20,000 total on Mr. Burrows.
Yes.
Ms. Sellers, good morning. Ms. Sellers, you're here because you've been accused of violating the terms of your county probation in case 25517 MM. Ms. Sellers, the allegation is that I think you were in a treatment center of some type, ma'am, and the allegation is you failed a drug test there. I'm appointing the public defender's officer to represent you. I'm going to ask you to listen to Mr. McDaniel and we'll see where we go. Mr. McDaniel.
Your Honor, I spoke to Ms. Sellers. She's going to admit that she violated her probation. Understanding should be sentenced to 6 months in the county jail, $370 fine, 71 days jail credit, and that will resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
Yes, Your Honor. Was that 71 days?
71. Ms. Sellers, did you hear that agreement?
Yes, sir.
Mr. McDaniel? I'm sorry, Mr. Goodson.
When she originally got put on probation, Judge, which was December 2nd of 25, she didn't have a fine assessed because it was stated that she worked her fine off at the jail. So I'm not.
Yeah, she was here
Your fine off before the probation?
Yeah. I don't know. She had originally sentenced her and then we withdrew that sentence and put her on probation. So there's no fine then.
Okay.
Ms. Sellers, is that the admission you would like to enter, ma'am?
Yes, sir.
Ms. Sellers, I'm going to accept your admission that you violated the terms of your probation, revoke that probation, ma'am. I'm going to sentence you to 6 months in the Jackson County Jail, ma'am. Judge you guilty of that offense, ma'am. I'm going to also give you credit for the time that you've already served, which is 71 days. It appears you've already got the fine and court costs taken care of. So what that means is you've got a few months left. You certainly may do less than that with some gain time. I would encourage you to check into the trustee program if that's something that interests you. But there's no more probation in this case. When you finish this sentence, you're through with this case, Ms. Sellers. Do you have any questions?
No, sir.
Ms. Sellers, I wish you the best.
Take care.
All right, I'm going to do something I rarely do here and hit the pause button for a second because we have a little bit of choose your own adventure going on. So I mentioned in the chat that Judge DeSanto is doing a trial. So I want to give you guys the skinny on this, and then you can make the decision what we do this morning. First off, it's a drunk driving trial. I figured out that much. This is her court paused at the moment. We won't have the normal visuals from her court. We will see her. It looks like we'll see the witness box. We will not see anything else. I have confirmed, though, that the audio from there is very good. So it seems like we can hear the attorneys and everything else. I can also confirm that once opening statements started, they got stopped. I'm not sure why, but something went down during opening statements and she sent the jury out and then started addressing the lawyers. So there's interesting stuff going on. I'm putting up a poll right now. You tell me if you're interested in that or not while we continue with Judge Mercer, and then we'll go from there.
We have Misty Merrill. Ms. Merrill, good morning. You're here because you've been accused of one count of possession of methamphetamine. There is probable cause in the complaint in your case, Ms. Merrill, and I've also looked at your criminal history. It looks like you've been to prison twice and were unsuccessfully terminated from probation about 6 months ago in a felony case. So, Ms. Merrill, that's the information I have. I'm going to listen to the attorneys before I set your bond. Mr. McDaniel, anything? Mr. Mitchell?
Just the standard random UAs.
Mr. Merrill, based upon you just getting off probation, I'm going to set your bond at $7,500 cash or surety. That's also taking into account your criminal history and that you were on probation for a drug-related offense. You do have a condition of random urinalysis, ma'am. That means you can be drug tested. In fact, you probably will be drug tested by Judge Garcia or someone at her direction. So you can expect that. It's probably coming. Your bond is cash or surety, Ms. Merrill. That means you don't have to come up with all of it, ma'am. You can go through a bondsman. And you will use the phone in just a few minutes to try to post that bond. Do you have any questions, ma'am?
No, sir.
Ma'am, wish you the best. The jail's going to give you a notice for your court date. It'll be April 7th at 8:30 in front of Judge Garcia in circuit court, ma'am.
Yes, sir. Thank you.
Thank you. We have Caleb Kessler. Mr. Kessler, good morning. You're here because a warrant came through for violation of state probation. It's a no bond warrant. Mr. Kessler, I want to go ahead and arraign you this morning and get you arraigned. We can get your lawyer appointed if you're asking for one. Mr. Kessler, would you like to have an attorney appointed to represent you?
Yes, Your Honor.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, please.
Y'all are going to have to not guilty. Yes, sit this on the April 23rd court docket. And there'll be an attorney from the public defender's office that'll stop by and talk to him.
Thank you. Mr. Mitchell, anything from the state?
No, Your Honor.
So, Mr. Kessler, that'll be your court date, and you'll see an attorney before your court date. Mr. Kessler, do you have any questions?
No, Your Honor.
All right, sir. I wish you the best.
Thank you.
Next, we have Michael Shipman. Mr. Shipman, good morning. You're here because you've been accused of one count of grand theft, which is a felony charge, and one count of contracting without a license, which is a misdemeanor charge. I'm going to appoint the public defender's office to represent you. I'm going to tell you there is probable cause in the complaint. I have read the complaint. I've also looked at your criminal history, and I see a few prior charges. Mr. Shipman, I'm going to ask that you listen to Mr. McDaniel, and then I'm going to address your bond status. Mr. McDaniel?
No, we just asked for a cash bond.
Mr. Mitchell, any objection to that?
No objection to a cash bond.
Okay. So I see an arrest on 2/25 of 26, but I think that may have been in Montgomery for this charge. Did you get picked up somewhere else for this charge?
No, I was picked up in Montgomery, sir.
Yes, that's
Okay.
correct.
I thought it was. I just want to make sure this wasn't something else I didn't know about. So, Mr. Shipman, I'm going to set you the normal $500 cash bond on the grand theft, $250 cash bond on the misdemeanor charge. Your total bond is $750 cash. You do have a condition of no contact with the alleged victim. And you also will be given a notice for your court date of April 7th at 8:30. Mr. Shipman, do you have any questions?
No, sir, I do not.
All right, sir. You'll get to use the phone shortly and wish you the best.
Thanks, sir.
Yes, sir.
Stay still.
Mr. McDaniel, anything else in the first appearance docket?
Nothing on the docket, Your Honor.
Mr. or Corporal Campbell, anything else from the jail?
No, sir.
State.
Nothing from the state, Your
I
Honor.
have one thing to kind of give y'all further explanation on in just a second. We'll do that once we get off Zoom and YouTube. But as far as Zoom and YouTube,
Good morning, ladies and gentlemen. Thank you for being with us today. So I want to briefly touch base on the elements again and my outlook of the case. So this defendant, Mr. Shannon Partman, he's charged with operating while intoxicated or impaired, which means you could find him guilty of either of those crimes. And so my focus will be largely on operating while visibly impaired. So I'm going to briefly go through each of those elements. The first is that the defendant operated a motor vehicle. To operate means to drive or have physical control of the vehicle. I believe that the testimony, as well as the evidence that you will see the video, will demonstrate that the defendant was operating this vehicle. He was in the driver's seat. That will be clear. Second element that I must prove is that the defendant operated the vehicle on the highway or other place open to the public or generally accessible to motor vehicles. Again, I believe that will be very clear, crystal clear. There will be body-worn camera, there will be a testimony, and so that will be very clear. Now, the third and final element that I must prove is that due to drinking alcohol, the defendant drove with less ability than would an ordinary careful driver. Now, you may have heard of the crime operating a vehicle while intoxicated. And he's actually charged with that today, but we're focusing on the visibly impaired portion. Now, with operating while intoxicated, one of the ways of presenting that is to show that an individual has an alcohol content of 0.08 grams of alcohol or more in their blood. Now, that is not the case with this crime that I'm trying to prove today. I do not need to show he had an alcohol count of a certain number. That is not what I'm focusing on. What I'm here to prove to you is that he was impaired. Now, when we're looking at what is the definition of impaired, now the jury instructions defines this crime. The defendant drove with less ability than would an ordinary careful driver. And so that is what I want you to focus on. Is this individual, the defendant, operating this vehicle with less of an ability than a ordinary careful driver? It continues. It states the defendant's ability to drive must have been lessened to the point where it would have been noticed by another person. So if his ability to drive is something that would cause another person to pay attention and notice it, that has to be shown. It continues to state, it is the defendant's ability to drive that must have been visibly lessened. Now, I want to hyper focus on this. Okay, so it is the defendant's ability to drive that must have been visibly lessened, not the defendant's manner of driving. Though evidence of defendant's manner of driving may be considered as evidence of the defendant's ability to drive. So what does that mean? So essentially what that says to me is that his ability to drive must have been lessened. And I will show that to you through the body worn camera, the vocal series, that's the way he speaks, all of this will be clear. Now, I do not need to show you that the manner of his driving was affected. I do not have to show that to you. However, in this case, I will. So I will show you that not only was his ability to drive lessened, but the evidence of how he was driving also will be displayed to you, where it will show that it was lessened. Even though I do not need to show that, it will be there.
Your Honor, may we approach?
Okay. Let's go off the record. No, stop. We're gonna excuse the jury. All rise for the jury. We're back on the record. Okay, you may be seated. Now, what I'm going to address first, number one, I'm not going to have the two of you arguing right here at the side or in front of the jurors. Number two, when I'm excusing the jurors, that means nobody's talking so that there's not any inadvertent comments or communication that the jurors hear. Okay, now, Mr. Bulahanis was appropriate in saying, shh, because when you're coming over here, you're loud. The reason for sidebars is so the jury doesn't hear the conversation that's being conducted. So then to get angry at Mr. Bulahanis right there, it's not appropriate. The behavior is not appropriate. What is it you wanted to address at the sidebar?
Your Honor, first of all, this is opening statement, it's not closing argument, number one.
Okay.
So you have to, when you're addressing the jury, you're saying the evidence will show. But what was happening is, even though the clear instruction is that the jury may consider the manner of driving, Mr. Mohammed was indicating that they don't have to consider it.
Counsel, I've read the instructions. They have a copy of the instructions, okay? If you think that Mr. Mohammed inaccurately stated something on opening, then you can certainly rebut that on your opening. But if, obviously, there can't be a misstatement of the law.
It was a
right?
statement of the law.
Hold on. There are jury instructions that will be stated and that are read and that they have copies of that correct that. Okay, but what I didn't hear was, I did not hear a misstatement of the law. What was it that Mr. Mohammed said?
He said, I don't have to prove, he said, that they don't have to consider the manner of driving. And when the jury instruction specifically indicates that they may consider the manner.
They may, it doesn't mean they have to.
No, but if you say you don't have to consider it, they have the ability to consider it.
Judge.
Okay, hold on. It is the defendant's ability to drive that must have been visibly lessened, not the defendant's manner of driving. Though evidence of the defendant's manner of driving may be considered as evidence of the defendant's ability to drive. They don't have to consider it. They may consider it. They don't have to consider it.
But the way he was phrasing it sounded like they should.
Okay, so counsel, that's for the jury to interpret, right? We have 8 individuals to interpret something that's being said. All 8 of them probably interpret something different.
And Judge, if I may,
Okay,
I can't help but think that, again, this is the defense attorney's way of taking me out of the flow of things. I know that I've had previous cases with him, and I'm just, that's my position on it.
Okay.
I think I was reading it straight. At one point, I was literally reading it verbatim from the jury instructions provided by the court. And so for him to cause the jury to, and this is opening statement.
Right, that's why we're going to resume. We're going to resume with opening statements.
He's interrupting me in the middle of my opening statement. So I think that's extremely inappropriate. I think he has no basis for it, and I think that
Counsel, he thought he had a basis. He thought he heard something that was not accurate, so he brought it to the court's attention appropriately as a sidebar. I ordered the jury out of the room based upon the behavior at the sidebar. So that's where we're at. All rise for the jury.
Well, the jury comes back in. Lindsay, thank you for the $20. Tritos for Ellie and the rest of the Soul fam. Thank you very much. And Ashley, thank you for gifting 10 memberships. Welcome to our new friends, including, who was it? Gold something. Apologies. It's a little blurry on my screen right now. But again, welcome to everybody. And thank you again, both Lindsay and Ashley. Gold Cazador. There it is. I can read it now. Sorry.
Okay, you may be seated. Okay, all right, we're going to resume with the people's opening statements.
thank you. And apologies for that, as sometimes I'll have to periodically throughout this case, the defense counsel might raise the objection and you'll have to be excused. So doesn't mean it has merit. Sometimes it may, sometimes it might not. That's for the judge to determine. Nonetheless, I'll continue where I left off.
So before you continue, I'm going to interject and indicate there may also be times when defense counsel is speaking that the prosecutor may object and there may have to be, you may have to leave the room as well. So it's both, it goes both ways.
Thank you, Eric. And so I will pick up where I left off, which was the third and final element. And I'll go through it one more time. I'm sure you've heard it a million times, but I have to just, cross my T's and dot the I's. So again, the third and final element was that due to the drinking of alcohol, the defendant drove with less ability than would an ordinary careful driver. And I want you to pay attention, ordinary careful driver. I don't think that the defendant in this case was very careful. And I think the evidence in the testimony will show that. The defendant's ability to drive must have been lessened to the point that it would have been noticed by another person. It was noticed by another person. That's why we're here. It was noticed by Officer Harris. And it is the defendant's ability to drive that must have been visibly lessened, not the defendant's manner of driving. However, in this specific case, the defendant's ability to drive was visibly lessened and the manner of his driving. So even though the manner of his driving is not a requirement to show this crime, it is evidence that can be considered, and we have that evidence. Because that's the reason why this officer conducted the stop, was the defendant's driving. You're going to see through the body-worn camera and the scout cam vehicle camera that he's weaving to the side. This is the middle of the night, cars moving to the side, the officer presumably had some suspicion, and then that's what leads to the arrest of this. Though evidence of the defendant's manner of driving may be considered as evidence of the defendant's ability to drive. So again, the evidence of his driving can be considered as evidence of his ability to drive. And again, when we go through the testimony and we go through the videos, we'll see all of that. So I will be straight to the point. We are not going to have a blood alcohol test result in this case, of a breathalyzer machine, or a lab test result. We're not going to have that. And that's why I'm mainly focusing on the crime of operating while visibly impaired. Because you will visibly be able to identify that this individual, the defendant, was impaired on the day in question. And so I'm going to just briefly touch on what I think will demonstrate this. And there's two things I really want you to focus on. The evidence and the testimony, because that is what we base our decision on. We do not base our decision based on hypotheticals. Defense counsel might try to push hypotheticals. They might try to suggest things that may or may have not happened. What we base our decision on are two things only. The testimony, which is what we will hear, and the evidence. Not focus on anything else. In this specific case, you will hear testimony that will suggest that there was an odor of intoxicants coming from the defendant. That the defendant's driving behavior was part of what led to the arrest. Some other factors were his speech. You will notice throughout the course of the evidence that's being presented, that will be presented in the video, that his speech is slurred. There's a specific word that sticks out to me is when the officer asks the defendant, what city are you in? I want you to pay attention to his responses. I want you to pay attention to how he responds. You've all gone to a bar, most of you have seen and are able to identify when an individual is impaired. Use that common sense. That's what this case is about. That is the theme of this case, is using common sense. Some of you have had experience with family members who may have had this type of offense in the past. You may have had experiences with family members or friends that have consumed alcohol to the point where they're intoxicated. Use that personal knowledge and common sense in making the determination along with the evidence and the testimony. Now, not only are we going to have slurred speech, an odor of intoxicants, the defendant's driving behavior, but we are also going to have the defendant's own statements, his own words, the defendant's own words that he was drinking on the day in question. He will tell the officer that. Now, we don't always have that, I'll be honest. What we do in this case, we have his own statements that he was drinking. The officer will testify in this case, and you'll hear testimony from him that that's not the only thing that led him to conduct an arrest in this case. He's going to see other factors, glossy eyes, potentially a blank stare. These are all different factors. The officer in this case conducted what's called standardized field sobriety tests. And throughout this test, the officer was able to identify clues. And those clues will be provided to you. You will hear the testimony on that. You will actually visibly see the defendant conducting this test, and you will be able to make the determination yourself. Now, defense counsel may bring in witnesses to suggest that this individual, the defendant, was insane, and they will make their argument. Ultimately, it's not that witness's decision to make. It's yours. You all are the trier of fact. And the key thing I want you to use in this case, common sense. They might try and sway you around, suggest things, and put the ball in different areas, but at the end of the day, just use common sense, and I know you will come to a just decision, and the law will be upheld, and the defendant will be found guilty. That is the people's position, and thank you for your time.
All right, Mr. Wilhelms?
Yeah, thank you so much, Your Honor. Good morning. Welcome to Middleton, Oregon, where you get all 4 seasons in one day. Thank you so much for your patience. I appreciate it. As I had alluded to before, this is one side of the story. So I think for you to keep your mind open so you hear both sides of the story and not to make any impressions. And I'll again remind you that anything that Mr. Mohammed says is not evidence. Anything that I say is not evidence. The questions put to the witnesses are not evidence. These are all part of the jury instructions, and you have a complete copy of the jury instructions, and you can always refer to those, okay? And so the only thing that is evidence will be the testimony from the witness chair and any exhibits admitted into evidence. That's evidence. And as the judge indicated, it's repeated in some portions of the jury instructions, you're only to consider the evidence, and which is the exhibits are evidence and testimony evidence. So that's what we'd ask you to do. And I think, one of the most important pieces of evidence would be what's called the dash cam. And the dash cam is camera that's all fitted in the police officer's vehicle. And the way it operates is generally when officers follow someone, they activate it, and then it shows the car in front of them, the suspect, so to speak. And so I think you should give that video great way. And because it takes you to where the officer was sitting. It shows you what the officer was seeing. And I'll ask you to remember this. The officer, when they stop anybody and they arrest them for any type of thing, they also prepare a police report. And the police report is used because they don't know when or if the matter is going to go to trial. And generally it's used to help them refresh their recollection. And I'll be talking to the officer about, everything he put into his police report versus what somebody might say and so forth. And so the testimony is the only evidence. So I'm afforded the opportunity to cross-examine them.
Good. We approach.
Approach. All right, you may continue, Mr. Wilhelms.
Thank you so much. So, your line, member of the as I indicated before, the and the exhibits, I indicated twice before, are the only, and that's what's considered evidence and so forth. And so, what I'd ask you to, that's all you can consider as evidence. That's the jury instructions. The jury instructions are in the law. And the jury instructions are supposed to be taken in a connected manner. And you're supposed to apply the jury instructions to everything you hear today or any exhibit that amendment. So, as I indicated before, we've seen the dash cam, Mr. Mohammed and I. And so we both know what's on the dash cam. And so, and I'm not gonna waste your time with, the first element of the crime is the defendant was operating the motor vehicle. We don't contest that. We don't contest that he was operating a vehicle on a highway, or a street open to the public. You don't even have to debate that, because we concede that. We're not gonna waste your time on it. What I need you to focus on, which is the crux of this case, and the evidence will show, is the key element is one of two things. Was he intoxicated by the consumption of alcohol? That's one charge. And the prosecutor is focusing on, was he, his ability to operate the vehicle? Remember, this is all about operating the vehicle. Was his operation of the vehicle visibly impaired? And those are really the two central questions. And so now, as there will be no evidence of any intoxilizer, breathalyzer, or blood test. So what you have to go by basically is the body cam of the officer and the dash and the testimony from this witness stand. So what the evidence is going to show is that my client was driving his vehicle on 4th Street. I was northbound, and it's going to show. And I'm not going to. You can look at the video yourself. You can ask for the video, and the video. Besides seeing it up here, you can ask for a copy back in the jury room. But what's going to show is that my client was driving in the middle lane. There were no other cars on the side of them, in front of them, and the officer was behind it. And you're going to see that the clip for the driving lasts no more than 50 seconds. And so you're going to see him driving in the middle lane, and he's hugging the left lane, and he's touching the line. When I viewed the video, at no point, I don't believe the evidence to show that he crossed over that other lane. You can watch the video and you're the judge. So I need to look at it. Because so he was driving in that manner, and then very shortly, that is to show, very shortly after the officer turned on his overhead lights, my client pulled over in a reasonable manner and parked his vehicle. So that's what the evidence can show. The indication of sobriety. See something, pulls over right away. Then, so that clip is about 50 seconds. The body cam clip, altogether, is just under 10 minutes. Okay. So, the evidence is going to show that my client admitted to having one beer. And at first he indicated a little bit, and then the officer asked him a couple times more. He said, "Yes, I had one beer." And so that's going to be testified. And so, in addition, what you're going to see on the body cam is, you're going to see that the officer asked my client to get out of the vehicle. And so what happens is my client does exit the vehicle, and when you watch the video, as he exits the vehicle, he doesn't use the vehicle for support as someone who's intoxicated or unable to force fire, and he doesn't stumble when he gets out of the vehicle. The evidence is also going to show that the officer administered a couple of field sobriety tests. One of the tests is called the horizontal gaze nystagmus test. And the test where the officer makes several passes like this. And so that's what's called a standard field sobriety test. There are certain rules that you have to follow, for that test to be done. Yeah, I believe the evidence will show that the officer did not follow those rules. And in addition, before, administering the field sobriety test, the officer, is required to medically clear the individual before, administering the field sobriety test. So I believe what the body cams have showed is that my client informed the officer that he had an exit, and that would affect his ability to do any field sobriety test that result that required damage. And so you see on the body cam that the officer indicates, well, I'll take that into consideration. And you also hear testimony that my client's disabled by social security due to his neck injury. And that it affects his ability to do anything requiring maintenance. So something that the prosecutor failed to mention is my client indicated to the officer that he had a head injury years ago, post-head injury, due to occurrence. And so these are the kinds of things that would medically disqualify a person from engaging in this test. We'll also be calling an expert witness who has trained at least probably in the neighborhood of 2,000 officers for the field sobriety test. That's what the evidence is going to show. And the evidence is going to show.
Judge, can we approach?
Okay.
By my count, this is 3 times now just during the opening statements that this has been stopped. These guys are getting a little spicy with each other. I'm curious to watch this thing today just to see how much they try to abuse each other.
Okay, yeah, no, I don't. Yeah.
Okay.
No worries.
That's all right. All right, you may continue.
Okay. All right. We'll be, yeah, I'm gonna take one quick break for a drink of water real quick.
Yes.
Fine. Well, slow. So you'll be hearing from an expert witness, you'll be hearing from a witness who has instructed and trained over 2,000 officers in the administration of standardized field sobriety testing. Additionally, he himself was an officer and had numerous OWI arrests as experience. And he'll also testify that he's testified as an expert in different courts. He's been qualified. And that he's made numerous, he's been trained for the standard field sobriety test and what the requirements are and how to interpret and what they're based on. So when you listen to all the evidence, I think that you're going to find that the prosecutor's case comes far short of establishing operating while intoxicated or operating while visibly impaired. Because I was gonna show that, the operation of the vehicle, the dash cam, there's no erratic driving indicated whatsoever. And when, as I said before, when, the overhead lights came on, pulled right over, just like you and I would right now. And so, keep me to that. And so, what we have is, we have an order of intoxication, which is nothing more than an admission of drinking one beer. And that the order of intoxication can easily be explained by drinking that one beer. And the, there's nothing in the officer's report about watery eyes. And I will be questioning the officer regarding his report. I want you to pay close attention to that. And the administration of the sobriety test and so forth. And I think that the prosecutor's burdens can fall far short. Again, there's no practice as indicated, no .08. There's no objective number. And so, again, it's the prosecutor's burden to the everything. As indicated in the jury instructions, and the judge repeated this twice at least in the jury instructions, that the defendant has no burden. That the total burden of proof is on the prosecutor. And so I would ask you to hold the defendant. And this whole case involves the operation of a motor vehicle. It's right in the elements of the case. And so you need to take the impairment in context. And you can take into consideration the manner of driving. That's probably the best evidence of whether or not he was able to operate the vehicle and normal behavior. What would you have done different? And so just so consider those things. I think for those reasons, after you hear all the testimony, that you find Mr. Parton not guilty. Thank you.
Great, and the people may call their first witness.
Thank you. Judge, for our first witness, we call Officer Connor Harris.
All right. Please raise your right hand. Solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Thank you.
All right, thank you. And please have a seat. State and spell your first and last names for the record, please.
First name is Connor, Connor. Last name Harris, Harris.
All right, thank you. And you may proceed, counsel.
Thank you. Officer Harris, are you currently employed?
I am.
Who's your employer?
The city of Wyandotte.
And in what capacity are you employed there?
I am a police officer for the city of Wyandotte.
And were you employed in that capacity as a police officer on October 2nd, 2025?
I was.
Did you work that date?
I did.
And did you work by yourself or with a partner?
By myself.
On that day, did you work in full uniform, modified uniform, undercover?
Full uniform.
And on that day, did you operate a scout vehicle or did you work foot patrol?
Scout vehicle.
And was your scout vehicle fully marked, semi-marked, unmarked?
It was a fully marked.
And on the day of October 2nd, 2025, did your duties as a police officer put you at or near the location of 4th Street and Antoine Street?
Yes.
That located in the city of Wyandotte, county of Wayne?
Yes, it is.
And when you were at or near that location, did something happen or did something catch your attention?
Yes.
And what drew your attention?
I observed, I believe it was a white Ford, driving in front of me. The vehicle was driving left of center. And it crossed onto the left, lane line, which caught my attention. And I also noticed that the license plate had a cover over it, which you're not supposed to have in the state of Michigan.
And what time of day was this? Was this early in the morning, nighttime?
This was late at night.
And was there any other vehicles that you could see, or was this the only one in your initial view?
I believe it was the only car in my initial view.
And so what specific, I think you said there was a license plate that was kind of covered?
The vehicle had a license plate cover, yes.
And so what else about that vehicle drew your attention?
Its driving behavior.
And so what specific about that driving behavior caught your attention?
The crossing onto the lane marker.
And so can you describe for the to the jury, how was it crossing over to the lane marker?
Well, essentially, you should drive your car in the center of the lane. Generally, when somebody is intoxicated, they will either veer to one side. We call that left.
Objection, non-responsive to the question.
Okay, your response, counsel?
Judge, I don't think that objection is even applicable at this point. I don't even think it's an objection the defense can make because it's
The
not.
objection was non-responsive to the question. So you asked a question and his objection is that the witness's response was not responsive.
And Judge, I was responding. It's not his objection to make, is my understanding. It's an objection that the questioner can get to the witness, not for an individual that, not for defense counsel when I'm asking the question. So if I'm asking him questions and he's not answering, then I can make that objection. But he can't say non-responsive to my witness. That's not how the rule is designed, is my understanding.
And which rule are you, basing your objection on, Mr. Bouhanis?
Your Honor, okay. When a witness is non-responsive,
Which rule are you basing your objection on?
relevance. Is there
Relevance or non-responsive? You said non-responsive.
It's non-responsive to the question. The witness is supposed to answer the question that's put to him. It becomes irrelevant when he addresses other issues other than.
Okay, well, hold on. So your objection was non-responsive. Mr. Mohammed is correct. If the question he asked was not responded to appropriately, that would be for him to object to and redirect the witness to. The court's going to overrule the objection based on non-responsive.
Okay.
Thank you.
Where did the objection basis of relevance?
Well, you're not getting two bites of the apple at the same time. You're not going to have two bites of the apple on the same question and answer. So let's see what I'm going to have you repeat the question, please, and then we'll see where that goes.
Thank you.
Thank you.
You're welcome.
Sir, do you recall the question?
Please repeat it.
So can you explain to the jury what you saw and essentially what led you to conduct the stop? As far as the defendant or the vehicle swerving through the lane, what did you see exactly?
I observed the vehicle cross onto the lane marker line, the dash line in the lane, which led me to stopping the vehicle.
And sir, is that a ticketable offense?
Yes.
To fail to maintain your lane?
Yes.
And based on how long have you been an officer?
I will be an officer of 3 years in May.
And based on your training and your experience as a police officer, is that sign or that ticketable offense usually indicative of something? Is that weaving across the lane or the marker line, is that indicative of anything based on your training and experience as an officer?
Objection mischaracterizes the officer's testimony. The officer never testified that he leaped into the other lane.
He testified that he was driving left of center and onto the lane marker. I didn't hear any testimony regarding the driver driving into the other lane. That was not testified to. So please make sure you're phrasing your questions with what was testified to.
Yeah, and Judge, just to clarify, I didn't mean fully cross into the other lane. I mean just the weaving to the left lane.
Okay, then
I'll clarify
that way. Yes, thank you.
Sir, in regards to just the weaving, I know it didn't cross into the next lane, but when a vehicle starts to weave close to that marker line, is that indicative of anything based on your training and experience as an officer?
Yes,
And what is that?
it usually signifies compromised driving ability.
And based on your training and experience, what type of driving capabilities are you referring to? What is an individual state usually at that point, based on your experience?
It's impaired.
And so you conducted a traffic stop in this case based off of that driving. Is that fair?
Correct.
And how did you initiate the stop? Did you use lights, sirens?
I signaled my overhead emergency lights.
No microphone?
No.
And when you activated your lights, did that vehicle pull over?
Yes.
And did you approach this vehicle that you had observed conduct this ticketable offense?
Yes.
And which side did you approach? The driver's side, the passenger side?
Driver's side.
And at any point, were you able to identify how many people were inside of this vehicle?
Yes.
How many?
One.
And where was that person sitting?
And the driver's seat.
They weren't sitting in the back on top of the car?
No, sir.
Okay, so this person that you had observed in the driver's seat, do you see that person here in the courtroom today?
Yes.
Can you please point to that individual and point out something that person is wearing?
Defense will stipulate that, the officer is referring to Shannon Carter.
Okay,
And the judge, I'd still like the officer to identify the defendant.
okay,
Thank you.
Gentleman right there with glasses.
well,
Well, it wasn't black tie, or blue.
well,
There you go.
black or blue, one who is
Black.
black, excuse me, one has black and one has blue,
Black tie.
okay.
And what is the jacket that individual, what color jacket that individual wearing?
Black.
Your Honor, please let the record reflect that the witness has identified the defendant by two articles of clothing, his black tie and his black.
Stipulate as indicated before.
Okay, all right, the record will still reflect.
Thank you. And when you made contact with the defendant that you identified here in court, how did that begin?
I'm sorry, can I say again?
You made contact with the driver,
Yes.
and that's the defendant?
Yes.
And how did that begin?
I approached the driver's side window.
And did the window come down?
Eventually.
What do you mean eventually?
If I recall, it did not immediately come down.
Do you know why not?
No.
And did the window eventually come down?
Yes.
And what happened at that point?
I could immediately smell the odor of intoxicants in the vehicle.
And what do you mean by the odor of intoxicants?
I mean, when you consume alcohol, there's a certain odor that comes off of the person who's consumed it.
And so was this odor of alcohol?
Correct.
And so what happened next? Or did you notice anything else at that point?
Yes, the gentleman, when I asked him questions, he had slurred speech.
And what type of questions did you ask him?
I initially told him why I stopped him regarding his observed driving. I then asked him where he was coming from. I asked him for his driver's license, and I asked him if he had any alcohol consumed in it.
Okay, and so before we get to his answer, I want to dive into a few things. So, besides his odor of alcohol, were there anything else at that point that you had observed in regards to the defendant and alcohol? Any other signs?
Not that I recall.
And what happened next after you asked him if he had anything to drink?
He stated a little bit.
And what happened next?
I asked him to clarify what a little bit meant to him.
What did he say?
He was hesitant and then eventually indicated that he only had one beer.
And so what happened next?
Well, due to his driving, his slurred speech, and the odor of intoxicants, I asked him to step out of the vehicle to perform a standardized field sobriety test, ensure that he was safe to drive.
Were there any other factors that led to you asking him out of the vehicle besides the odor of intoxicants, his driving behavior, and his admitting to consuming alcohol? Anything else observed at that moment?
Slurred speech.
In regards to the slurred speech, can you describe what you mean by slurred speech and how he was slurring his speech, if you know?
I would just describe it as not clear and concise.
Were there any specific words that would stick out to you, or was there a certain type of pattern of speech that may have drawn your attention?
Yeah, he just didn't speak as a normal person would generally.
Okay, and so you indicated you asked him out of the vehicle?
Correct.
And so what happened next?
He took a minute to exit the vehicle. If I recall, I had asked him more than once. And then eventually he did exit the vehicle.
And was there anything else that you noticed at that point prior to beginning your standardized field sobriety test? Was there any observations that you made or signs of impairment at that point?
Nothing additional.
Are you sure about that?
That I recall it.
Do you believe if you had an opportunity to review your report that would help refresh your memory?
Well, yes.
Do you have a copy of your report?
No, I'm just looking, just making sure.
Mr. Mohammed. Yes,
Coach Llewellyn.
you may.
Also take an opportunity and review that, and once your memory's been refreshed, just let me know. Has your memory been refreshed?
I believe so.
And so besides the odor of intoxicants, him admitting to drinking, his driving behavior, were there any additional factors on exiting the vehicle that was observed on the defendant?
Are you referring to the blank stare?
No, counsel, or Mr. or Officer Harris, you can't ask a question.
Sorry.
If you're asking for clarification, you can ask for clarification. However, please be aware that Mr. Mohammed cannot ask a leading question. So the question was, after reviewing the report, is there anything that refreshes your recollection about anything else that called your attention to the defendant?
No. And which standardized field sobriety test did you have the defendant or ask him to perform, if any?
Initially, all of them.
And so let's go one by one. What was the first test, if you recall?
HGN.
And can you describe to the jury what that test is and what it consists of?
HGN is a eye test. It stands for horizontal gaze nystagmus. What it is when you are impaired, essentially your eyes make a jerking motion. They don't move smoothly from side to side when you're looking in a direction. They make a jerky motion that shows signs of impairment.
And was that test performed by the defendant in this case?
It was.
And what happened during that test? Were there any clues observed or what happened?
Yes, he was explaining the test. We conducted it and he displayed, 2 of the 3 categories that we look for. He displayed 4 clues out of the 6.
And what was the clue? What were the clues?
A lack of smooth pursuit in both of his eyes and, sustained, nystagmus at maximum deviation.
And so what does that mean?
That essentially means, lack of smooth pursuit. We have you follow a stimulus from side to side without moving your head, just your eyes only. Your eyes are supposed to move smoothly when you look left to right. If you're impaired, your eyes will essentially skip or make a jerky motion. It's described like turning your windshield wipers on when there's no rain and your windshield does that windshield wiper makes that skipping gesture. Your eyes are supposed to move from side to side without that. When you're impaired, your eyes will actually skip back and forth. So that is a lack of smooth pursuit.
Did that happen in this case?
It did.
And it was that defendant's eyes that did that?
Yes.
And what additional tests did you perform? If any?
The second
Ask the defendant to perform.
The second HGN test we performed was the maximum deviation, which is essentially another portion of the eye test where when your eyes are maximum, left or right, if you hold it and sustain it, your eyes are not supposed to skip like the previous test. And in that case, his eyes were skipping.
And by his eyes, you mean the defendant's?
Correct.
And based on your training and experience as an officer, are these clues that you observed in regards to this HGN test, or also known as horizontal gaze nystagmus test, are those clues indicative of anything based on your training and experience?
Yes.
What is that?
Intoxication.
And so, were there any other tests that you had conducted at the field to determine whether or not you believed the defendant was impaired at that point?
Yes.
What other tests did you conduct?
We performed the walk and turn.
And can you describe to the jury what that consists of and whether or not that test was conducted by the defendant?
The walk and turn is another standardized test. Essentially, you start by having somebody stand on a level surface and have them imagine there's a straight line in front of them. The idea of the test is to walk heel to toe on this imaginary line. It's a balance test to see if you can maintain your balance. So I read in the instructions and had to perform it.
And so, what did you observe the defendant do during this walk and turn test?
The defendant struggled and had, there's 8 clues that we look for during this test. The defendant had nearly all of them.
And do you recall exactly how many of the 8 clues were present in this case?
I believe 7.
Now, I don't want you to tell me what you believe. I want you to tell me what you know.
7.
And are you positive?
Yes.
All right. And were there can you describe what those clues were that you saw during this walk and turn? And if you need it, if you can't recall, just let me know.
Can't recall.
Will having the opportunity to review the report help refresh your memory?
Yes.
Your Honor, may I approach the witness?
You may.
Just for the record, I showed it to defense counsel.
Okay.
Is your memory refreshed?
Yes.
And do you recall the question?
Yes.
And so what were some of the clues that you had observed during the defendant's performance of this test?
He failed to maintain walking a straight line. He failed to maintain stepping heel to toe. We are required to have him take 9 heel to toe steps. He took too many steps. He was unable to balance during the instruction phase, and he started too soon.
Okay, friends, I had to step out of the studio for a minute and I come back and it looks like we're struggling to show body cam. Is that what's going on? Like a tech thing? Let me know in the chat. We're a few minutes in the Wayback Machine. I can push forward if I need to.
Officer, I want to draw your attention to this video.
So counsel, this is an exhibit?
Yes, but I'm going to lay some additional foundational.
Okay, so you're,
Foundational questions.
okay, so you're playing the
Yeah.
video that you have as proposed.
Yeah, and so Judge, it is going to be proposed exhibit number 1. It is what appears to be the scout cam vehicle of this incident. It's on evidence.com labeled as Fort and Antoine. And just for the record, it's spelled FORT and ANTOINE.
All right, thank you. And if you can, if you can expand the.
Yes, of course.
Okay.
And before I do that, I just want to state that I'm going to publish for about 10 to 15 seconds, ask some foundational questions, then attempt to admit at that point.
Okay. And is this a stipulated exhibit or no?
It's a stipulated exhibit as long as the prior conversations regarding the restrictions, apply.
Right, as far as the parameters with the tone.
Right.
Okay. Right.
And Judge, I still plan on asking my foundational questions with a
That's fine. I just was trying to just ascertain whether or not, there'd have to be, a motion to admit or if it was stipulated to.
Officer, I'm going to just draw your attention to the screen, please.
Can all the jurors see the screen? Okay, all the jurors answered in the affirmative.
In publishing from 0 seconds. Pausing at 3 seconds. Officer, do you recognize this video?
I do.
And how do you recognize it?
This is my dash cam.
And is this a fair and accurate depiction of your dash cam on the day in question that we're here for today?
Yes.
And is this the same vehicle that you had observed start to veer to the left?
It is.
Objection leading, the video speaks for itself, Your Honor. He can ask a non-leading question.
Well, the court's going to overrule that objection as the answer has already been answered, has already been provided, and the question wasn't suggesting an answer.
Thank you, Your Honor. And sir, is this a fair and accurate depiction of the day in question and the vehicle you stopped?
Yes.
Does this video appear to be altered or manipulated in any way? Your Honor, at this time, I move into evidence People's Proposed Exhibit number 1.
Again, defendant stipulates to this, Your Honor, subject to the discussions had on the record prior to the jury being compelled.
Okay, so stipulated and so admitted.
Thank you. And Judge, publishing from 3 seconds, but officer, I please identify for the record when you start to see the reason you conducted this stop. Publishing from 3 seconds. Right there. Sorry, it did not pause.
Because you paused it at what time?
I paused it for the record at 16 seconds. And just for the record, I'm going to republish from 0 seconds and just slow down the time, the speed.
Okay.
Apparently, it does not allow me to slow down the speed, so I will just.
Well, I think it's at the slowest one it can go. Because when you had that up, it said 1 time, 2 time, 3 time, or 4 time or something. So this may be as slow as it goes. I don't know.
Yes, for this specific video, I've had other videos where I can slow further, but this video, for some reason, doesn't allow me to do.
Okay, let me just ask a clarifying question, counsel. Officer Harris, can you see the time up in the lower left-hand corner? I know this is not an eye test. I'm just wondering if you.
I am blind. Currently, yes, I can.
Okay, so counsel, what may be most effective is if the officer can testify or indicate at what time on the lower left-hand side of the screen he observes the behavior that you asked about instead of right there, so that can be a proper time.
And you get a little closer so I can see from back.
Yes.
Thank you.
Just let me know when you're.
Can you see better, Mr. Bubahanis?
A lot better.
Okay.
Thank you.
All right. Publishing an officer again, just the time, just let us know when you see it. Publish, and if you need to get closer, just let us know as well. Thank you. Publishing from 0 seconds. I believe it's 12 seconds. And
Okay. All right, so we paused at 13 seconds. Please state that for the record.
yes, I paused at
We have two
13.
excuse me, especially because we have two that are learning. So,
I paused at 13 seconds. I'm reversing to 4 seconds and publishing again.
okay.
So officer, it's the vehicle moving to the left or the right? To the left. And stopping
At what time?
at 18-second mark.
Well, you did stop at 17 and jump to 18, just so you know. So you were correct the first time you were saying 17, but okay.
And so officer, I'm going to keep your attention on the screen.
So council, that was People's Exhibit 1 or 1? Okay.
And Judge, for the record, this is going to be People's Proposed Exhibit number 2. It's labeled on Axon as Axon, AXON, Body, BODY, the number 4, Video 2025-10-2, 0050, B as in David, 01, AG 1729. This will be People's Proposed Exhibit number 2. It's the body worn camera of Officer Harris is what I believe it to be at this point. I'm going to publish for a few seconds and then lay foundational questions and then move to admit at that time.
Okay. And Mr. Bulahanis, is this also one that's stipulated to with those clarifications addressed before as well?
And may I stand up there again so I can see the time?
You may.
Thank you, yeah.
All right.
Thanks, I appreciate it.
Publishing from 0 seconds.
Hold on, council. You're fast forwarding it.
No, I'm not.
Okay, I'm looking so I apologize.
Aggie.
How's it going, sir? Good. Reason we stopped you is it looks like you're having some difficulty maintaining your lane. Okay. You crossed the lane line a couple times. I did? Yes, sir. Okay. You got your driver's
Judge,
license?
pausing at 1 minute and 18 seconds.
From tonight.
Okay.
Judge, is it possible to turn off the court?
Brett, review home.
White. Oh. Oh, shit. There we go.
Is it possible to?
All right, so now we're paused at 1 minute, 38 seconds.
Correct.
Okay.
And I'm going to rewind, but is it possible to raise the volume of the speaker by chance?
We can try that.
because the statements by the defendant, his speech, his pattern of speech is very important at this point.
Okay, Dee, do we have the remote there for the actual TV? Is that it?
Yep.
Is the volume all the way up? Okay, so now it's up. Hopefully, we're not going to blare out any eardrums with the officers volume with the officers speaking.
Thank you. And Judge, it's currently stopped at 1 minute and 38 seconds. I'm going to reverse to 1 minute and
I'm sorry, 1 minute and what?
3 seconds.
Okay.
Publishing now.
How's it going, sir? Good. Reason we stopped you is it looks like you're having some difficulty maintaining your lane. Okay. You crossed the lane line a couple times. I did? Yes, sir. Okay. You got your driver's license on you? Sure. Where are we coming from tonight? Riverview. Riverview? Yep. We're at Riverview. Home?
Pausing at 1 minute and 29 seconds. Sir, is there anything during that point of interaction that caught your attention in regards to the defendant's speech?
Yes,
And what?
the way he said Riverview.
And what about that pronunciation was it that drew your attention?
It's slurred speech.
And I'm going to, Your Honor, it's paused at 1 minute and 29 seconds. I'm just going to reverse to 1 minute and 18 seconds and
Okay.
publish for the record again.
Lane line a couple times. I did? Yes, sir. Okay. You got your driver's license on you? Sure. Where are we coming from tonight? Riverview. Riverview? Yep. We're at Riverview. Home? Wife's house.
Pausing at 1 minute and 35 seconds. Officer, you just listened to another portion where you asked the defendant where he was coming from, and he responded. Do you recall what he responded?
Yes,
And what was that?
wife's house.
And is that pattern of speech indicative of anything?
It's a regular.
And so again, Judge, I'm moving back from 1 minute and 35 seconds back to 1 minute and 5 seconds, and I'm going to publish again.
Okay.
How's it going, sir? Good. Reason we stopped you is it looks like you're having some difficulty maintaining your lane. Okay. You crossed the lane line a couple times. I did? Yes, sir. Okay. You got your driver's license on you? Sure. Where are we coming from tonight? Riverview. Riverview? Yep. We're at Riverview. Home? Wife's house. Oh, shit. There we go. You have anything to drink tonight, sir? A little bit. A little bit? You still living on Michigan Boulevard? Yes, sir. Alrighty. How much is a little bit? A little bit. Like a beer, a glass of wine? A beer. One beer? Two beers? 3 beers? It's not sure. It's a question. A beer. 1 beer? Yeah. Okay. Alright. Well, if you do something, step out. We're going to run some field sobriety tests. Make sure you're good to get home, okay? Just step out for it. Do you have any weapons or anything, eh? No. Okay. Step out. And lock the car. Okay. Alright, step up. So turn face car for me real quick. Alright, you gonna stand back here for me? Stand back here. Go stand, go get out of the roadway where it's safe. Okay. Alrighty. Beautiful. Can you take your glasses off for me?
Okay.
Perfect. Alrighty. You wear, you obviously have your glasses on. Do you have any medical conditions that affect your eyes?
Yes.
What do you have?
My neck is bad.
What does that have to do with your eyes?
Vertigo.
You have vertigo?
Yes.
Okay. You have astigmatism or anything like that?
Yes.
All
With
right.
my glasses.
Alright. You have any head injuries in the last couple weeks or anything like that?
Not a couple of weeks, but life, yes.
Alrighty, perfect. What I'm gonna have you do, face me, put your feet together, arms to your side, just like that. Beautiful. Can you see the tip of this pen? Can you see the tip of the pen? You follow with your eyes and your eyes only, okay? Nope, don't move your head. Your eyes and your eyes only.
Okay.
Look at the tip of the pen there. See it?
Yeah.
You're looking past it. Right.
I'm looking right at the pen.
Alrighty. There you go. Perfect. Alrighty. I'll have you stand. Yeah, you can put your glasses back on. Yep. I'll have you stand right here. Right in the middle of the square, right where my foot's at. Perfect. Face that way, just like you are. Beautiful. Alrighty, so what I'm gonna have you do, I'm gonna have you take you're gonna imagine that there's an imaginary line right down the middle of the sidewalk, okay? What you're gonna do is you're gonna put your left foot on that line, right foot right in front of it, heel to toe, just like this.
I'm going to tell you because of my neck.
Uh-huh.
That's me hard, so I'm just saying that.
Okay, that's fine. We'll take that into consideration.
Okay.
So again, you're gonna keep that left foot, boom, planted right on that imaginary line. You're gonna take your right foot, put it right in front of it, arms at your side, just like this, heel to toe. Can you get in this position for me?
Sure.
Alrighty, go ahead.
Is that good or no?
Nope, let me explain it again.
No, I'm asking, is this okay?
There's an imaginary line.
Okay.
Left foot,
On the concrete, okay.
right foot, right in front of it, heel to toe, just like this. Whoa, hey, don't fall over on me, buddy. Let's try again. Let's restart. Ready? You're not following instructions. Feet together, arms at your side. Imaginary line, right down in front of you. Left foot on that line, right? You got your left foot right on it.
Judge, pausing at 6 minutes and 21 seconds. Officer, can you explain for the jury what test is being performed by the defendant at this point?
This is the long term.
And so this is the same test that you had identified 7 of the 8 clues that the defendant had?
Yes.
Thank you. And Judge, just reversing back to the 6 minute and 9 second mark and publishing.
Okay.
Let's strike that 6 minute and 1 second. Publishing now.
Okay.
Imaginary line.
Okay.
Left foot,
On the concrete, okay.
right foot, right in front of it, heel to toe, just like this. Whoa, hey, don't fall over on me, buddy. Let's try again. Let's restart. Ready? You're not following instructions. Feet together, arms at your side. Imaginary line, right down in front of you. Left foot on that line, right? You got your left foot right on it. Right foot, heel to toe. Stay in that position. Do not begin until I tell you to.
Okay.
Do you understand?
Yes, sir.
All right. What you're going to do, sir, is you're going to take 9 heel-to-toe steps down that imaginary line. When you get to your 9th step, you're going to keep your lead foot planted, take a series of small steps to turn around, and take 9 heel-to-toe steps back. I will demonstrate. It's going to look like this. 1, 2, 3. You're going to go to 9. On your 9th step, you're going to keep your lead foot planted, take a series of small steps to turn around, and take 9 heel-to-toe steps back. 1, 2, 3. You're going to go to 9. While you're doing this, you're going to keep your arms at your side the entire time. You're going to count your steps aloud the entire time, and do not stop the test until it is completed. Do you understand?
I think.
It's a yes or no. Do you understand?
I think. I don't know. You're doing a lot.
What part do you not understand?
I'm just saying what you're saying, so.
Okay, do you understand
A
it?
lot.
Do you understand the
Yes.
test? 9 steps down, small series of steps to turn around, 9 steps back.
Okay.
When you're ready, you may begin.
So you said go.
Just like I explained it.
Okay. Oh, okay.
Alrighty, perfect. Are you able to balance on one foot on either choice, just like this?
No.
Publishing or stopping video at 8 minutes and 36 seconds.
Right?
Officer, based on the performance of the defendant during this walk and turn test, based on your training and experience as a police officer, was the results indicative of anything?
Yes,
What?
impairment.
And prior to publishing the walk and turn test, there was a portion where you were moving the light and at the defendant's eyes. And what test was that?
It was a pen stimulus, it was an HGN.
And based on the results of that test, were you able to determine whether or not there were any clues?
Yes.
And
Objection asked and answered, Your Honor. The officer already testified as to the clues on the HGN. He said there's 4 out of 6 clues. This testimony has already been submitted, and so this has been asked and answered.
Well, actually, he testified there were 7 out of 8 clues.
No, that's on the walk and turn down. He's talking now about the
Oh,
HGN.
he is talking about that. Yes. Okay.
And
So he already testified that there was, out of the 3 tests, 2 out of 3. He testified to this already.
I understand. Your response, counsel?
Judge, I had not played and published the video at that point, so I'm just laying foundation that 1, this is the same test. And 2, I was just gonna ask him a final question, like what did the results of that lead?
Okay, well, hold on. You can respond with what you were intending to do, but you can't ask the question in your response to the objection.
Oh,
So, okay, but the court's going to overrule the objection. The court would, you may continue.
thank you. And sir, based off of the test, the HGN test with the light that was just demonstrated to the court, were you able to conclude whether or not there were any signs?
Yes.
And based on your training experience as a police officer, what are those signs indicative of?
Impairment.
Thank you. And Judge, I'm just going to reverse a few seconds back to around 8 minutes and 19 or 21 seconds and publish the report from that point.
Okay.
And I intend on pausing at 8 minutes and 57 seconds.
Okay.
Because of my neck.
Because of your neck injury?
Yes.
Alrighty. Beautiful. Alright, at the state of Michigan, at the request of a peace officer, I'm requiring that you take a PBT, a preliminary breath test. Failure to do so shall result in a civil infraction, up to $100, and you can still be placed under arrest. Will you be willing to take that PBT for me?
I don't want to.
Alright, turn around, put your hand.
Okay.
It's paused.
Hold on.
Can we approach that?
Hold on.
Hold on. Let me approach. All right, I'm gonna have the jurors, we're gonna have the jurors step into the jury room.
Interesting day here at TCF. You got to admit that this is not exactly the crime of the century or the trial of the century.
Okay.
But it's interesting.
So, counsel approached. The, Mr. Bulahanis says he wants to move for a mistrial.
That's correct, Your Honor. We specifically addressed this issue, several times. And we also addressed it before Mr. Mohan started to play a video. Third meeting to stop it before the refusal of the EBT. Your Honor, you can't unring the bell. The bell has been wrong. So.
The bell has been wrong as to what?
As to the PBT refusal.
Okay, so I'm going to give Mr. Muhammad an opportunity to respond, but what I will state is that, and I'm not sure if you can see from here, but I can see Mr. Muhammad's cursor go on and hit, and so I saw the cursor go on and I could see that it was pushing where the pause button was. Let me just indicate that. So, and I saw that for some reason, even though he was pushing it, there seems to be some delay. I will also note that it appeared as though he pushed it at 56 seconds, and I note on my notes that at 8:57 is when you all agreed to stop playing the video. I will also note, since I could tell that the video was still playing, not by any intentional act, it appeared from Mr. Mohammed, I started speaking loudly, and I don't think that anybody heard anything, because I couldn't even hear his response on there, because I started saying, okay, hold on, and Mr. Mohammed even started speaking so that nobody could hear what was going on. So, I don't believe that anybody heard anything as far as an answer to the question, because there was a lot of other commotion being made to make sure that that statement was not heard.
May I respond as well?
Just one moment, Mr. Mohammed. So I know that you know the answer that was coming from there, but are you telling this court that you heard the answer?
I thought I heard the answer, yes.
You thought you heard the answer?
Yeah.
Okay.
Yeah.
That's not my question. Did you in fact hear your client refuse the PBT?
Yes, I did.
Okay. So let me just ask this question. Hold on. Mr. Mohammed, can you go back at the 8:57 mark, please, and press play? This is 8:56.
Will you be willing to take that PBT for me?
I don't want to.
All right, turn around, put your hands behind your back.
Okay, hold on a second.
You are under arrest.
Hold on. So we didn't even say no. So he said I don't want to. Oh, hold on, counsel. Hold on. That was at 8:58, at which point I don't believe that was, I know that it shows it was paused at 8:59. I don't believe the jury heard anything, but I'll let you continue.
I'll say, I heard it, and Your Honor, I'm not saying that Mr. Mohammed did anything intentionally. It could be negligent, it could be just, even a computer. That's irrelevant. The relevancy is that, there's a ruling on this, and we've we're going to great pains to make sure that certain things don't come in. The court's already made a ruling on these things. I distinctly heard it, Your Honor. And so if I distinctly heard it, I mean, I guess the jurors, maybe one of the jurors heard it too. I distinctly heard it.
Okay. But just a few moments ago, you thought you heard it. So, Mr. Mohammed, I'll give you an opportunity to respond.
Judge, I recall, as the court indicated, moving my mouth over at the button at 8 minutes and 56 seconds and clicking it at that point. when the video actually was paused when the court was making the record, it was paused at 8 minutes and 59 seconds. Why there was a delay, I'm not sure. But I don't even know if at 8 minutes and 59 seconds, the defendant had disclosed the refusal at that point. I would like to play it and just confirm. I remember picking 8 minutes and 57 seconds as a safe zone because I know I just wanted to click it before we even got to that statement. So I'm not even gonna concede that at 8 minutes and 59 seconds, the statement's even said at that point, which is where it was.
We're going to play it. We're going to play it at 8 minutes and 56 seconds. And let's continue on for just for a few seconds, even after 8 minutes and 59 seconds.
May I say something here? Well, is there any chance like the court reporter would have been able to pick it up?
We're going to
pay the court reporting man?
we will check that as well. However,
That's what I would suggest.
however, I want to hear this 8 minutes and 57 seconds. Let's go to 8 minutes and 56 seconds and then continue to play even a few seconds after the 9 minutes.
May I stay for it?
Yes.
And Judge, if I may, I think it would be best if I approached Your Honor with defense counsel and published it straight from the laptop because there might be some sort of a delay.
No, I want to do it from here because I need to know I need it to be a real time thing.
So it's currently at 8 minutes and 54 seconds.
Okay.
I will pause it at 8 minutes and.
No, I don't want you to pause it. No, I'll tell you when to pause it.
Alright.
So just keep your mouse hovering over there,
So
please.
you can still be placed under arrest. Will you be willing to take that PPT for me?
I don't want to.
All right, turn around, put your hands behind your back.
What I do?
You are under arrest for operating while intoxicated.
What I do?
So we're
before
gonna
that?
pause that.
Judge, I had clicked pause and it was still playing up there.
Counsel, I understand. I'm not suggesting you did anything wrong, and I don't think Mr. Bulahanis is suggesting that either.
No, I haven't suggested that.
So, just a moment, girls, can you unplug the headset and replay that back from when the video was playing while the jury was in here? Okay, and then we're going to see what we hear.
Yeah, I think.
Or we're gonna hear what we hear.
With me being that close, it looked like that it came out at 8:58.
No, it did not come out at 8:58.
That's what.
It was 8:59. I was watching, it may have started at like the back half or towards the end of 8:58, but it was 8:59.
Made in public, the video and the speech was made on the internet, went to the team. And two, I was going to ask them a question, like, what is the reform?
Okay, so we'll just keep playing it from here. Can it turn up anymore? No, we need to hear. They are in another closed room. Okay. Okay, thank you. All right, so I hear I don't at the beginning, okay, and then we all start talking. Okay,
Your Honor, if I may.
hold on, we have to plug back in the headphones here.
Yeah, there's one.
No, of course.
Still blood split is for.
Maybe we can make a note to label the plugs when Alicia brings her leave.
Thanks. You're next to each other. Okay.
Yeah, we're gonna make a note to, we're gonna have Alicia bring her label maker in so we can label that too. Okay. All right, so, I think that we can do a couple of things to determine what, if anything, the jurors heard. We can bring the jurors in one by one and ask if they heard anything, or if they heard an answer to the officer's question.
Yes.
If they did, then we will proceed from there, okay? Also, I do believe if there is an answer of yes, there can be a corrective jury instruction that indicates I don't want to, doesn't necessarily indicate a refusal, right? Because they don't know what happened after that. They're not going to know what happened after that because that's not going to be admissible. That's not portion of the video that's admissible. I don't want to doesn't mean no, right? There's not any other indication that there was further conversation, right? That your client then said no. So I do believe that we could do a corrective jury instruction. But first, before we get there, we'll ask each individual juror if they heard the answer to the question.
And Judge, if I may, just two things. Number one is, as the court and everyone heard, as soon as any response was starting to happen, we all started to respond and kind of scream essentially, so that it takes whatever was going to come out of the video. And number two, I think the court is correct. The jury instruction would correct it. Also, my understanding is we have 2 extra jurors. And so if one of those individuals, one of the 8, had heard the response, I would have no objection to removing that person and leaving the 7 neutral jurors at that point.
Okay, Mr. Mohannes?
Yeah, I know, I'm gonna have a continued, I think once you ring the bell, you can't unring it. And I think the natural, thought process is if someone says, I don't want to, that means no. That's just my argument for the record, and I just want the court to know that.
Well, sometimes I say I don't want to come to work, but I still come to work, so that doesn't mean no, right?
That this is a little bit different.
Or if my kids ask me if they can have something and I say I don't want to give it to you, doesn't necessarily mean no. It means maybe I'm not going to give it to them. Who knows? I'm saying that and it didn't even say the whole thing, right? It started off as I don't, and then we all started speaking over it to overpower any response. You're correct. That's what we're going to ask.
We don't know.
I'm going to ask.
Yeah, that's fine.
Just so we're clear, I'm going to ask the jurors the same questions. Did you hear the response to the officer's question about taking a PBT?
Yeah, that's
it. I was going to ask that.
And if so,
I know I have to ask afterwards. But first, I just want to make sure that it's asking the same question to each of the jurors.
yes.
And that you're both in agreement with the question that's going to be asked. Did you hear the defendant's response to the officer's question regarding preliminary breath test?
Taking over.
No, I'm just going to say regarding the preliminary breath test. I don't want to infer either way that there had to be a test taken. I'm just going to indicate in general regarding preliminary breath test.
Okay.
Okay? Are you both satisfied with that question?
Yes, I am.
Yeah, Your Honor, and just, I understand that you made a ruling on the PBT and everything. I just think it's, again, that's fine. We'll just go from there. I'm not gonna say anything else.
Okay. All right. So what I'm going to do is I'm going to mute the live stream. We're going to turn.
Well, there we go. Okay. All right, friends. And just a couple of minutes after she said, I'm going to mute the live stream, she cut the live stream. So I'm looking at her feed right now, and she is not back live. So I think we're going to move on based on the amount of time that we have left in the day. We may have to circle back with this on Monday if it continues. And I imagine that it will continue. However, I'm just going to continue to state my views on the matter. My prerogative as the host, I suppose. I have huge, gaping, massive problems with this whole situation. I don't think there was probable cause for the stop. I think he clearly indicated to the officer that he was not going to take that PBT. And the officer immediately took that as a no because he handcuffed him. I think this was an officer, in my opinion, who was reaching for a DUI. He pulled him over on shady grounds. He said he saw him cross the line, quote unquote, a couple times, where we only saw one time where he barely touched the line in the video. There's a lot of shade here that bothers me. But anywho, nothing more we can see about it at the moment. But if Judge brings this back, I will work to capture that footage and we can pick it up on Monday. All right, bad news. It's Friday the 13th, but there is no dungeon court today. They are not running. We do have a half an hour left, though. So let's watch some more court. We'll go to Judge Elmore. I think he's doing a sentencing in Missaukee County, but we'll check that out. But please let me know your thoughts on what we've seen in the chat, because if you disagree with me or whatever, let's have the conversation. I'm not happy with what I saw there. Judge Elmore.
Thank you, Your Honor. Good morning. David Houghton on behalf of the people.
Robert Hackett appearing on behalf of Mr. Woodworth, apparently in both cases today.
Apparently. All right. Well, one of them is actually just being nollied, if I understand correctly. So
that is correct, Joe.
That one, all I've got to do is put a signature on a page, so we're good to go there. All right, let me pull up the right file. There it is. All right. Are you Mr. Woodward?
Yes, I am.
All right. Thank you very much. Also here before the court this morning is Miss Laura Odell. She is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. Let me take a quick look. I don't think I had any corrections, if I recall.
There are a couple of additions that we just learned about this morning, Judge.
Yeah, I'll turn it over to you all. 1 second, though. On CFJ 284, page 8, looking at the defendant's adult history, that first entry for status at the time of the offense looks like the offense was 12/23/94, but he had a couple juvenile cases that were charged, had alleged events occurring back in December and even November. Was he on bond at all at that time, or probation?
I apologize for interrupting you. It actually looks like that should be included in the juvenile section.
Okay, and that was, so either he would have been a juvenile at the time or he would have been on some kind of bond that he had absconded, yada. And the reason why I thought maybe it was an absconding was because the discharge date is 98, but again, the disposition is 94 still. So yeah, we need to move that down into the juvenile section.
Thank you.
Yep, no problem. All right, let's take a look here and I'll keep on going. All right. So that concludes what I had to address. Let's turn it over to the prosecutor. Mr. Denham?
Thank you, Your Honor. On CFJ 145, page 2, with respect to the jail credit, it's my understanding that Mr. Woodworth was in inpatient treatment beginning on February 10th, 2026. So the credit should be modified from 57 days to 27 days, I believe, Your Honor.
Yeah, thank you. And I thought he was in treatment, but when I saw that, I couldn't remember if I had revoked it or something. All right, well, thank you very much. Mr. Hackett, I assume you don't object?
I do not, Judge.
Any other changes, corrections, or objections on behalf of the people? No, Your Honor. All right, Mr. Hackett, the ball now is back in your court. Any corrections or objections?
No objections, Judge. Just a couple of additions. On page 18 of the CFJ 284, under the substance abuse treatment section, you did order him into inpatient treatment at DOT. He went in on February 10th, and he successfully completed that program on March 10th of this year. So I think that the end date should be put in there, and obviously he completed it.
All right. Yeah, that's perfect. Thank you very much. We'll go ahead and make that change. Any other corrections, Mr. Hackett?
No, Judge.
All right. Thank you very much. We'll begin with allocution from the people. Mr. Denham.
Thank you. Your Honor, the people do support the recommendation. In some respects, the one, I guess, area that the people would differ somewhat with the probation department is the recommendation is for there not to be any community supervision, for there to be a straight jail sentence. We understand the recommendation is based upon the defendant's prior history on bond and prior substance abuse convictions. However, there was a significant period of time where, according to the PSI as well as the defense, where the defendant was free from illegal substances. He has just now gone through inpatient treatment successfully, and we believe that a period of probation with testing would be appropriate to ensure that Mr. Woodworth continues on his path towards substance abuse history, freedom from substance abuses, from substance, all illegal substances. So that's one area that we would differ, but in other respects, we would support the recommendation.
All right, thank you. Mr. Hackett?
Thank you, Your Honor. There was a jail cap in this case, Judge. Guidelines are 10 to 23 months. I'm going to ask, Judge, that you go ahead and either give him credit for time served at this point, or go ahead and suspend any additional jail so that he may stay out and continue to work. I know that he has obligated himself or his company to a number of projects in 2026 that he's already taken money for. I don't want him to see him get in any legal issues with regard to that. Not suggesting he would. He's done 30 and 30 for AA classes, NA classes. He does have the sign-in sheets there he can provide you, Judge. He will continue to do that. And I also know that he has outpatient services intake on Monday. That he'll begin the outpatient services, and he will follow through on all of that, Judge. He's doing very well. He's probably better than I've seen him. And I've known Mr. Woodworth for probably 20 years now. Thank you.
All right, thank you. All right, Mr. Woodworth, you have the right to make a statement if you choose to do so before the court issues a sentence. Is there anything you wish to say at this time, sir?
Yes, Your Honor.
There you go. Thank you.
Your Honor, I would ask this court to consider a downward departure from my guidelines to the 57 days I have served, along with imposing a substantial fine, which I am prepared to pay to the court in full today. I believe this departure can be warranted based on the fact that I take full responsibility for my possession of dangerous drugs, along with my completion of inpatient residential rehab in the 30 meetings and 30 days I voluntarily did in addition to the residential treatment. I stand before you today with 2 months of sobriety under my belt and no desire to return to active use. I'm a small business owner with lots of ties and obligations to this community. Being in the event rental business, many of my clients often book events with paid deposits months and sometimes years in advance. I am a hard worker. I own my home. I pay my taxes, and I want to be an asset to the community by being able to fulfill my current obligations. That said, if this court does not see fit to sentence me to time served, I would humbly request any additional time ordered be suspended, therefore allowing me to keep my home and my business intact.
Thank you. All right, folks. As I often say, it's not until this moment in a criminal case in which the court is allowed or is charged with exercise. Oh, you may go into a seat, sir. Exercising its discretion. And so I'm going to go over several things and the law, and for particularly the appellate courts require trial courts to explain as much as possible about their justification for the sentencing. Well, and some of this I just have to know, because if I don't, somebody will pick at it. Well, we begin by looking at CFJ 145, page 1, and we see an extensive history of alcohol and marijuana beginning when the defendant was a juvenile. And then as he grew, it added to, for a short period of time, I don't know how much, but at least a little bit for a 2-year period, there was cocaine use. There's been methamphetamine use for the last 5 or so, and there were opiates for about a 10-year period of time back in his young adult time. So he struggled with substance use disorder a great deal. And we see that, of course, referenced in the history back in CFJ 284, where it talks about the defendant's attendance at treatment. And again, he's had multiple attempts at treatment, and some have been successful, and I greatly appreciate and acknowledge that, because that is a positive here. Sentencing is not always about penalty, but is also about rehabilitation. And so here he had completed some other programs, and most recently completed the program that Mr. Hackett discussed. And I think that's a great opportunity for Mr. Woodward to have had, and I hope that it sticks with him. Now, when we talk about the defendant's prior criminal history, it's quite extensive, both as a juvenile and as an adult. And within that history, and of course, by the way, I want to make sure it's stated on the record, the court does not consider any case that was dismissed. So there were some that were dismissed as a juvenile. I'll note that a few may have been dismissed in exchange for a plea in the other case, but I don't have any facts, so therefore I can't make a finding by the preponderance of the evidence to consider those. Therefore, the court does not consider any file for which the defendant received a dismissal, whether it was dismissed as an agreement or is dismissed just outright. The defendant has had some issues, both as an adult and as a juvenile, with crimes of dishonesty. We see a breaking and entering in 1994. And while on probation, he picked up multiple cases. Again, a couple of those were dismissed. But one of them in 1994 involved receiving and concealing stolen property, as well as use of controlled substances, specifically marijuana. And while that case was pending, actually about a week later, he picked up another case, and that was a unlawful drive and away of a motor vehicle. And then, and as I mentioned earlier, there were multiple ones all bunched up together. There was another one also within that month period of time that involved a break-in and entering, and then another one that involved a break-in and entering, uttering and publishing, and unlawful drive and away. And then in 95, which was only about a month or two later, he picked up another case involving escaping from lawful custody while he was awaiting trial. So in there were some significant series of cases. Well, then he picked up that other one in 94 that also had to deal with controlled substances. So until he became an adult, there was quite a history. And that has continued even as an adult. The defendant began in '96 with some criminal charges and convictions. And right away, while he was on probation or juvenile supervision, he committed yet another property crime and was placed on and given a chance of probation, and he was unsuccessful with that probation. In fact, he was on bond for that file when he picked up the next case, which was, sure enough, a property crime. And then there was another case at the same time, also on violating bond, and yet that was another property crime. And what's important here to note is that the defendant did not, he was given a period of probation and a boot camp. He didn't complete either one successfully, and then was sent to prison. Well, while he was on parole after being released, he was paroled on October 28th of 1999, and he made it about 9 months before he picked up a violation and committed another offense. While it's not significant, maybe not overly significant, it wasn't operating while intoxicated. So again, we see issues of controlled substances. Well, while he was on parole, and maybe I would assume bond for that last one, he picked up yet another one, and that was 13 days later, driving license suspended. Not a big case, but this court takes a look at those and sees that it's kind of a crime of dishonesty as a person is doing what they want to do, hoping they don't get away with it, but sure enough, they get caught. Then about a year later, he picked up a disturbance of peace down in Grand Rapids. After he was discharged from that case and that was resolved, he made it 3 weeks in 2002 before picking up another property case. And looks like he had some parole. Yeah, he got a prison term. Then when he got paroled on March 15th of 2005, he made it 4 months before picking up another offense, and that was a drinking and driving. He received 12 months of probation and 85 days jail, and he tested positive within a short period. Well, I'll take it back. I'll say he made it 4 months, 5 months before testing positive for cocaine, and his probation was discharged unsuccessfully. Well, after that case was discharged, he made it 2 months before picking up some other offenses. Those were in this court, and they involved assault with intent to commit a CSC in the second degree. At least when he got there, he was paroled and had no violations. Well, but I should say, he actually had 2 cases going on at the same time, both involving criminal sexual conduct, and both resulted in, looks like, a prison sentence, and he had no violations during parole, which was very positive. Well, after all that, and he was released from parole, he made it 8 months before he picked up some weapons charges, being a felon in possession of weapons, which is concerning. When we had the CSC cases, and then we have weapons, there's no charge apparently for having used the weapons, but there's an element of dishonesty here. Well, with that, he even apparently had some violations on his probation. So now we jump ahead about 5.5 years until 2022. And sure enough, we end up, well, there are charges for violence, but it was resulted with a disorderly person for jostling. Now, that would have been in front of me back in 2022. Looks like he entered a plea for domestic violence and was given a kilo-brew agreement where it was reduced. So that was successful. And he made it about 1.5 years before picking up a minor offense, driving license suspended, but that's concerning to the court is whether or not he's going to comply with the orders of courts, not to violate laws, not to drive, the rules of the state, don't drive unless we tell you you can. And then after that, which was resolved on January 6th of 2025, he made it 3 months before he then picked up another driver's license suspended. So that's telling me that he's not going to learn his lesson there. After that case was resolved on April 28th of 2025, he made it just less than 2 months before he picked up the pending offense. Now, in the meantime, while the charge offense date was June 17th, and he hadn't been arrested until October, in the middle, there was this other charge, and that's the other case that we're here to dismiss today. So I've got a series of repetitive crimes, acts of violence, acts of dishonesty, acts of failing to comply with probation, comply with bond, comply with parole. And of course, I need to make a note here in this case that the defendant had violated this bond multiple times, and that information is contained in this report on CFJ 284, page 3. In fact, there was a lab test confirming that he tested positive for methamphetamine, and it was a relatively significant amount, 1,780 nanograms per milliliter, and also some failures to test in the middle there. So the court clearly, when it elected to allow him to go to the treatments, because I'm quite concerned, and whenever I give a sentence, the sentence is supposed to be a balance between the person, the offense, and the objectives of sentencing. Now, because the court is allowed to consider and make findings based upon a preponderance of the evidence, and there's been no objection to the contents inside the PSI, this case doesn't need to go any further, at least my judgment. CFJ 284, page 3, paragraphs 1 and 2. CI met with Woodworth and money was exchanged for methamphetamine in the garage. Woodworth placed the methamphetamine into a partially consumed bottle of water to conceal it in case of police contact. The CI then followed Woodworth into the main area of the house and spoke with him briefly before leaving the residence with methamphetamine dissolved in the water bottle. After exchange, the CI drove to a predetermined location. Now the next paragraph. The liquid inside the bottle weighed 184 grams, including packaging. So, Mr. Woodworth is a drug dealer. Now, he hasn't been convicted of delivering drugs. He received a significant benefit in this case. A delivery of methamphetamine would have been a Class B offense, not a Class D. And as a fourth habitual enhancement, I guarantee you most likely would have scored undoubtedly a prison sentence with a maximum of life. Or as a second or subsequent, the guidelines and the minimum could have been doubled, and the maximum could have been doubled as well. So, again, this court understands that there has been a Killebrew agreement, and this is why I do not do Cobb's agreements. This is specifically the example why. Because I don't know all this information. I don't get it presented to me when I'm taking a sentencing. And this is why I often speak whenever I talk to other judges. I would stop doing Cobb's agreements because of this example. So there is actually, I'm going to let, because it's a Killebrew agreement, of course, the defendant's going to have the right to withdraw his sentence, and but the court still has to give a sentence. The court assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court costs as this case has been processed throughout the system. The court's going to assess a $5,000 fine. There is no attorney fee because counsel is retained. There's no supervision fees because I'm not going to place the defendant on a period of probation, and I am not going to follow the pretrial agreement for a jail cap. This is a drug deal. No, I have no idea how anybody thought that I would comply with this, but I still have to give a sentence, and the defendant will be allowed, pursuant to the pretrial agreement, to withdraw his plea. The court sentences the defendant to a prison term of 23 to 120 months and awards the defendant the 27 days of credit. The facts of this case demonstrate that the defendant is a drug dealer. Now, also, I'll even note in here, one of the statements was he recognized that, hold on, I'm going to find it because I want to get it. On CFJ 284, page 1. It is hoped he realizes that he is less likely to be respected and to be seen as a professional if he is known to be engaging in the sales and use of dangerous controlled substances. Yeah. Therefore, that's the sentence of the court. Mr. Hackett, do you need to speak with your client and talk to him about his desire to withdraw his plea? Or do you
Yes,
or do you already know? All right, no problem. What I'm going to do, Mr. Woodworth, is you are ordered not to leave the building, but you may step out in the hallway and you may use one of the rooms out there to call into Mr. Hackett. Do you have a cell phone?
Yes, sir.
Mr. Hackett, do you have your cell phone with you?
I do, Judge. I'm actually on it. Can he go ahead and zoom into your number, Judge?
Yes, I will write that down for him. Linda, you will take it out to him.
Thank you, Judge.
No problem. Thank you very much. All right, Linda. Bond is hereby revoked, and we'll continue in a few minutes. Thank you. We'll go into recess in that one, and we'll wait for him to chime in there, Linda, and then I will move to the next file once you.
Okay, friends. So we are in the Wayback Machine on this. So let me see if I can push it forward and see if he comes back, because I don't know about you, but I'm curious to see if he withdraws now. This has probably been one of the weirdest days we have had at TCF. We started out with that tragic situation where, you know, the guy got 30 days for death. We got this weird trial going on where who knows what's going on there. Judge DeSanto still isn't back. Maybe she sent him to lunch. I don't know. And now this thing. It's really odd. Oh, yeah. Oh, no, they're talking to the guy in the jail. Here, maybe? Okay, let's try this.
All right. We're going to take up back the file of People versus Michael Woodward. Again, the two files are 25-3630 and 3650FH. The court recognizes before the court all the same parties and counsel. And Mr. Hackett, you're still able to see and hear me? All right, thank you very much. Mr. Hackett, were you able to speak with your counsel, or did you have any problems with the technology?
I was able to speak to Mr. Woodward, Judge. I spoke to him on the phone.
Hold on. Let me have Linda. One sec. Oh, they're gone.
There we go.
You were able to speak. You were able to speak with him.
I was able to speak to him, Judge. And, you know, based upon the Killebrew agreement to a jail cap, he would like to withdraw his plea, and then he would request that bond be reinstated so that he can continue to defend his case. His case is.
All right. Thank you very much. The court by law and pursuant to the pretrial agreement under Killebrew, the court therefore grants the request to withdraw the conviction and the sentence and the case. And I assume that the other case, I'm not going to sign a McNally process this time. Is that correct, Mr. Denham, or do you still want me to sign that?
No, Your Honor, that we would not be entering at the time.
All right. Thank you very much. Now, earlier I said bond was revoked. Largely that was because I didn't want the defendant to leave the building. And I know we had a detective that was available to help monitor that. So now the question is requested by Mr. Hackett on Mr. Woodward's behalf, is to reinstate bond Mr. Denham, your position, sir?
Your Honor, it probably is already a condition, but we would ask that the testing be a requirement, Your Honor.
Sure, no problem. Thank you. All right, well, the court generally sees a concern in these situations because now I've made a statement as to where what the court is focusing on for sentence and what the court is likely to do. What's in a different situation here is the defendant and counsel now again have heard what the court finds to be important about the case. Now again, that is all based upon what was in the PSI. The PSI no longer really exists to me at this time. So it's no longer a factual consideration and for sentencing, but it's relevant to this court for considering potentially what to do on bond. As I mentioned, we've had a variety of bond violations, probation violations, parole violations, repetitive offenses over and over again. And the court now knows more about the case, and the court underneath Court Rule 6.106 recognizes that the likelihood of conviction is somewhat high based upon at least the facts as I understand them now. This involves a system used by detectives that involve informants, searches, generally audio. I don't know if they had audio here. But things like that. And the defendant faces a potential of up to life. Now, he did do a treatment program. He hasn't fled, but he did the treatment program after getting the benefit of the pretrial agreement. So, Mr. Hackett, what does your client do again? Help me from looking back into the report. What does he do for work?
He's the owner of basically a tent company. He goes ahead and contracts with private parties and for weddings and graduations and outdoor events that would need some type of structure in order, I assume, to be safe from the elements. So
yeah, all right. So I understand what that is. All right. Well, thank you. All right. Well, the defendant does have a record of appearance. We didn't, but he had a variety of bond violations before, and that's quite concerning to the court. And I only modified the bond, right, to allow him to go to the treatment program. Is that right, Mr. or Miss Odell? Is that what you recall?
That's my recollection, yes.
All right. Well, now that I understand the nature of the offense a lot better, the evidence behind the file, the defendant's prior criminal history, and the performances I discussed earlier, the court is going to deny the modification of bond, revoke bond, and remand him into the custody of the Missaukee County Jail. This case will now be set back on the court's trial docket very quickly for a next pretrial conference and a new trial date. Thank you. We're adjourned.
Somehow that was a fitting end to the day. A little bit of a roller coaster there. It went from an agreement to where the defendant was asking to have time served be considered to a withdrawal of the plea to bond revoked. Crazy. But it was that kind of a day. Sorry we didn't have Dungeon Court on Friday the 13th, but we had some very interesting weird court, so somehow it still fit. I hope y'all had fun. I know I did, so much so that we'll do it again on Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. If you're not a channel member, consider fixing that. This is a great community, and we would love to have you be a part of it as a channel member. But we'll see you on Monday. In the meantime, go have yourselves a good weekend. We will be posting some things throughout the weekend, so keep an eye out for your notifications. But otherwise, go have fun. Take care. God bless.